Lordship, I beg to mention item number 20. Since learned CGC, Mr. S.K. Mehdi is out of station.
Item number,
20.
you have informed the other side.
Yes, Your Lordship, we have taken the consent. We have taken the consent, Lordship.
On the request of learned CGC, made with the consent of the other side, this matter, hearing of this matter stands adjourned for 3 weeks, list accordingly.
Lordship, this matter may be taken on 7th of this month.
That we can't say, we'll see when it comes.
Obliged.
Yeah, please, Lord. Also, I'd like to mention item number 8. It was by the last order, it was fixed on 2-3.
8, it is submitted at the bar that this matter was fixed on 2/3/2023, but it has been wrongly listed today. Also, registry to verify and list the matter accordingly.
Obliged.
May I please yours? Well, I pay for listing the motion that for tomorrow from agency.
What is the urgency?
Regarding my S condonation, my last there is my submission of application on my 10th.
Hello, please.
May I please, Your Lordship? Why not we have filed a stay vacation application along with an implement petition and for praying for listing the IS the next week. Next week, we have some.
Wednesday.
I beg to mention for listing of this for admission, Lordship. This matter will be listed.
The mic is not working.
I beg
Yes,
to mention for listing of this for admission, Lordship. This matter may be listed on next.
after 2 weeks, put a date, after 2 weeks. Yes.
May I please, Your Lordship, I beg to mention a WPC. It's a pension matter, my lord. The petitioner husband was died on 19. After that, she has not get any pension, my lord. So matter may be taken on next week any day.
After 2 weeks, put a date, after 2 weeks. Yes,
Yeah, please, Your Honor. I beg to mention an writ petition which has been filed but not yet listed for motion.
when do you want it?
10th of February.
Yes.
Obliged, Your Honor.
May I please, Your Lordship? I pray for the listing, Lordship.
Hmm.
Appointment for the Gaon Pradhan, Lordship.
After 2 weeks, after 2 weeks.
Lordship, I'm very sorry to say, Your Lordship, we have not received any instruction. I just talked to the ADC today. I got some telephonic instruction, Your Lordship, in this regard, and he has said that the DC has sought some report from the circle officer. I asked him why that is necessary when the order is already there. And secondly, he said that this amount, total amount will down to around 20-21 lakhs or something like that. And therefore, they will possibly have to write to the finance department or something to release the money. But this is only my telephone.
So we'll issue notice, motion, these matters cannot be sorted. I heard Ms. P. Chakravarti, Learned Counsel for the petitioners, peruse the statements made in the writ petition. The aggrieved by non-payment of workmen compensation, which was earlier sanctioned by the authorities. The writ petitioners have approached this court by filing the instant writ petition. Full stop. Mr. C.S. Hazarika, Learned Government Advocate Assam, appearing for the respondents, submits that
Respond number 1.
appearing for the respondent number 1 submits that he be granted some more time to obtain instruction in the matter. So many of the above issue notice of motion returnable on 10th March 2023. Since Mr. Hazarika has accepted notice for respondent number 1, your petition is defective. You have not made this state a party.
That was there.
On that ground, it may be dismissed later on.
Let me,
You file an application. And Mr. Who's for the finance and Mr. R. Bopujari, Learned Standing Counsel, Finance Department, Assam, has appeared and accepted notice on behalf of the respondent number 2. Service of notice is deemed to be complete in this case. Extra copies of Mr. B. Gogoi, Standing Counsel, Finance. Extra copies of writ petition be furnished to the Learned Departmental Counsel. First, to enable them to obtain instruction, facilitating disposal of the writ petition at the stage of admission hearing.
My lord, thereafter, what happened, my lord, his date of joining was given as 2013. By being affected by that, my lord, we filed a writ petition, and the writ
So
petition.
we'll have to issue notice at this stage.
My lord, there has to be a stay of the, my lord, because my lord, may just let me just, my lord, just at page 44, my lord,
Stay of what?
my lord, stay of notification at annexure 12, page 79, my lord. Where Lord, my lord Biren Datta, executive engineer, after his retirement, a junior to me has been given the charge, despite of the fact that the Honorable High Court of this has indicted my seniority by judgment passed in 18/11/2022, my lord. And the judgment is at page.
So if it is stayed, then
Yes, ma'am.
you will automatically become in charge, is it?
No, my lord, because.
No, you tell us one thing.
Yes, my
See,
lord.
these proceedings are not only about your client and you. That's not the case. If this notification is stayed, how does your client get to benefit? Tell us.
No, my lord, because I will get the benefit, my lord, because the being this high court has already been held that my seniority would be intact from.
So if it is stayed, it will be automatically you.
No, my lord.
Yeah.
Let the stay be there. Because if the stay does not happen, my lord, he goes the charge over me. And as by the order of notification, my lord, there is a particular line which affects me, my lord. That
Yeah.
till a substitute is posted in due course and until further order. So, my lord, they have not even in fact, the seniority list which they have taken out, they have clearly mentioned that my date of joining will be as subject to the outcome of the writ petition at page 55, at page 330, serial number.
Yes.
330, my lord.
Where is the seniority list?
My lord, the seniority list is page 50.
Page 50. All right. This was published when?
This was published by the special and commissioner secretary.
When was it published?
My lord, this was published in May 4th May 2022.
Okay.
And my judgment was in.
1 minute,
18.
1 minute.
Yes,
You will have a lot of things to answer. Don't
yes,
deny.
yes, lord.
Where is your client's name?
My lord, my client is at 330. My lord.
330. Yes. And where is the name of the private respondent?
288, my lord.
All right. Now what has happened?
My lord, the judgment of this honorable high court is at page 44. And the effective part, 26. Paragraph 26, page 44 of the writ petition.
Yes.
Accordingly, it is provided for all the other purposes other than for payment of salary and allowances, the petitioner to be treated to have been in service and the service period of the petitioner to be taken from the date of initial appointment up to the date when his service came or would come to an end as per law, and accordingly subject the petitioner to all such benefits that he may be entitled. As the entire period which was forfeited as per the impugned order has been interfered, therefore the petitioner would now be considered to be a new entry in the service after the would not be considered a new entry in the service after the order imputed 21/8/2018. Writ petition stands as indicated above. And I have communicated the same to the department. And
So the seniority list has not been interfered with.
no, my lord, if as at page 55, it has been clearly written that my seniority will be subject to the outcome of the writ petition. And my seniority has been given from the date of initial appointment. And my date of initial appointment is.
So is there a direction to refix your seniority?
No, my lord, my petition, my prayer, yes, my lord, there was a prayer. That is why that was the writ petition that I had filed to refix my seniority, and that is
That has not been granted.
That's not been granted, my lord.
What to do?
No, my lord, that is why the state, because this honorable high court has already given my seniority, my
No,
lord.
you get a clarification first, whether the seniority list has been interfered with or not.
No, my lord, it has been interfered, my lord, because it has been in a service, my lord, paragraph 26. My lord, just look at annexure 2 once. Annexure 2, page 20, my lord. That is my date of joining, 30th June 2003.
Yes.
And my lord,
And the learned judge says you would be construed to be a new entrant in.
no,
service.
not to be considered to be a new entry. Not, it's the word is not, my lord. Not to be considered a new entry. So my lord, what has happened at para 35, at annexure 5, page 33.
Hmm. Yes.
My lord,
Yes.
it has page 33. See, Debajit Pujari has submitted representation on so and stated after completion and came back and to join in Assam PW Assistant Engineer on 36/2003. And thereafter, the speaking order at the end, what they had done a dice run to my entire service, and they took me as a service from 2013. My lord may find that at page 34. So I filed a writ petition against this order, and the Honorable High Court thereafter gave my date of initial appointment from 36/2003, and I communicated the same to the department. And so, my lord,
Mr. Dhar, you are appearing. What action has been taken by the department after this order?
My lord, that I have to seek instruction, my lord.
We'll find out.
Yes,
We'll have it
after the
next
first time.
Friday. Yes.
my lord, till then, at least the stay may be granted.
Then I will reject your prayer and issue a notice of rule.
No, my lord, if the charges
All right,
is, my lord, may
All right, heard Mr.
my lord, please, my
SP
lord.
Sharma, learned counsel for the writ petitioner. Assailing the order of. Where is the order? Order dated 30/1/2022. Issued by the Under Secretary to the Government of Assam, PWB. Have you committed that you will get him a stay order?
No, my lord,
Then
I have
you
not
seem to
committed that.
be
No, my lord,
jumping on it.
how would I commit that?
I will reject your prayer for stay order because you are not allowing the court to inquire.
No,
into this.
I apologize for that, my lord.
We only wanted him to get an instruction and tell us in what manner the single judge's order has been acted upon. Because the single judge has observed something but has not set aside the inter-se seniority list. These are matters which have implication. Have the patience and temperament to understand that you need to learn a few things about service jurisprudence.
My lord.
It's not that you come to the court and give me order, give me order.
No,
and
my
court-
lord.
That doesn't happen.
No, my
All
lord.
right, now you will have to face the consequences, can't help it.
No, my lord, may
so
at
and
least
so,
step for instruction, my lord.
On the ground that notification dated so and so, alleging that despite the order dated 18/11/2022 passed by the learned single judge in WPC number 121 of the 2019, upholding the contention of the petitioner insofar as his claim for seniority is concerned. The respondents have neither altered reviewed the inter-se seniority list of the department, and on the contrary has made the respondent number 7 as the in charge What is the name of the respondent number 7?
My lord, at page 79, my lord, at 5, second last, my lord, Sri Gulab Bora, Sri Biren Datta, Executive Engineer, Tiok and Murini,
The respondent number 7
to Sri Gulab Bora, that is.
as the in charge assistant executive engineer bracket civil till a substitute is posted in due course and until further order. Full stop. According to Mr. Sharma, the respondents could not have made the official respondents could not have made the respondent number 7 as the in charge as AEE bracket C by ignoring the seniority claim of the writ petitioner. Full stop. Mr. R. Dhan, Standing Counsel PWD, Assam prays for some time to obtain instruction in the matter. Full stop. In view of the above, issue notice of motion favorable on 27/2/2023. Since Mr. Dhar has appeared and accepted notice on behalf of respondent numbers 1 to 6. No formal notice is required to be sent to the said respondents. Extra copies of the petition be furnished to the learned departmental council requisite in numbers in order to enable him to obtain instruction and appraise this court as to what action has been taken by the department pursuant to the order dated. The order dated
One. Yeah, page 36, my lord.
18/11/2022 passed by the Lanesh single judge in WPC number 121/2019. The instructions so obtained shall be placed on record in the form of an affidavit. Petitioner to take steps for service of notice upon respondent number 7 by registered post PTD within 3 days from today. Heard on the prayer of interim relief, the said prayer will be considered on the returnable date. The respondents would, however, be at liberty to take corrective measures, if any, in this matter, in the light of the observations made in the order dated 18/11/2022, if so advised. Mr. Sharma, the fight between departmental candidates would be relevant for you, but it is not relevant for us.
My lord.
We only go by the law.
My lord.
So come prepared on the legal points.
My lord.
How does it matter to us? Who is the in charge officer? Why should we grant a stay here? Make out a case and get an order. We have not been able to make out any case for stay.
My lord.
Item 24.
May it please your lordship. You know, the petitioner is the senior most secretary in
My
the
lord,
camp.
my lord, before my finger starts, my lord. My lord, WPT is a party and I have not been served with copy. Unless, my lord, I get a copy, usually in such matters, my lord, I brief our additional AG. And he takes a call whether he will appear or not, my lord. These matters got a lot of implications, my
My
lord.
lord, the WPT department is supporting our case, so we are providing
I
them
do-
a copy now. It is a nodal agency which will support our case. We want their presence. And we are giving
Okay,
him.
you
a
are
copy.
telling him or directing him?
No, I'm not
Support.
directing him. The fact that he has made it.
He is not supporting your case, that's what it is.
No, no,
But he doesn't know what is your
He has
case.
to support the
My lord-
case once the rules come in.
My lord, I just got the copy. I don't know what is there inside.
Yes, yes. Only
My
this
lord,
is against.
my prayer would be let the madam have come up tomorrow, my lord. I have no issues,
No,
my
no.
lord. Tomorrow, let me go through the brief today, my lord.
My lord,
Even I should
My lord, the thing is that I took permission yesterday because of the urgency. This is a case where without publishing a gradation list, the respondent government has already promoted. I come to know about a gradation list, which is not cadre wise, after I check up the website, and the website shows 900 officers without cadre. So the promotion orders, as soon as I get, I build up my case on the ground that first of all, you have violated the rules because I am on the top. But it's similar to the yesterday's case. And the most important part is that the second important part is that the L-shaped.
Mr. Das, are you
Yes.
seeking any interim order?
No.
Are you seeking any interim?
No, now what will happen? One person has already retired yesterday. They will promote another, and in the meantime, I've already prejudiced. What I want, Lordship will issue notice, and one post may be kept vacant because this person on the earlier occasion also. Yes.
issue notice. I have
He has
no
already
problem.
approached this court. He has approached this court because he is applying for the All India service. There's an interim order of this where his grades were brought down.
The problem is you have made the department a party, but he says no copy was served.
No,
So
that
he is not-
Malay, just now I come to
Yeah,
know.
that's right. So he is
But,
asking for
the
posting
third
it tomorrow.
part I won't go now. The fact that.
He is asking for.
Yes,
taking
yes,
it tomorrow.
he has been given a copy, but the note, he is a party, he is a department which supports my case. So can I not
Heard
press for
Mr.
it?
D.K. Das, learned counsel appearing for the lead petitioner. Also heard Mr. S.S. Roy, learned government advocate Assam appearing for respondent numbers
1, 2, 4, 5,
1,
4 and 6.
4 and 5. You are appearing?
Our name was reflected in the contract, but we were not made party in the distribution.
Your name is reflected in the cause list.
Yes.
You are appearing in this case.
Accountant general.
Is there any caveat in this case?
No, it is clear.
Accountant general, but they are not a party in this.
Accountant, no, AG is not a party. I have nothing to do with my salary. I'm
Mr. R. Dhar, Learned Standing Council, WPT and BC submits that although the department has been made a party in this case, yet no copy of the petition has been served upon him. This promotion is to which post?
to the post of commissioner secretary. That's the FX skill. And he didn't get it. And he was number 1 in the secretary. So what I pray, Lordship will issue notice, pendency, subject.
No, we'll
to
fix
one
it
person.
tomorrow because
Again.
you have to give him notice. Mr. Dhar submits that since a copy of the writ petition has been furnished to him just now, hence this matter be taken up again tomorrow, so as to enable him to obtain instruction. Mr. D.K. Das, Learned Counsel for the petitioner, on the other hand, has expressed extreme urgency in the matter by submitting that the process of promotion might be concluded
Yes.
in a day or two.
There's a resultant vacancy.
The process of promotion for filling up the resultant vacancies
Yes.
arising in the post of commissioner and secretary.
Commissioner.
Secretary to which department?
Well, the commissioner, it's a scale. Secretary is the head of the department under the rules of
Commissioner and
exchange.
secretary to the government of Assam might be concluded in a day or two, full stop. Situated thus, this court is left with no option but to directly register to list this matter again tomorrow for motion by reflecting the name of Learned Counsel for the respondents in the cause list.
If today it's held mandated protection.
Sorry?
Suppose the resultant vacancy they have done, because the government now is not a benevolent government for me, it's a malevolence. So at least without the leave of the court, because tomorrow I'll make my submission, he will get the copy.
We'll see tomorrow. But Mr. Das, availability of this bench is uncertain tomorrow, so it may go to some other bench also.
Small correction is there. There's one small correction is there with your leave.
Yes, sure.
Maybe let's order stating.
Lord, IA has been filed by the department.
This matter may kindly be taken after September.
After some time, after how much time?
After the at the end of the list.
Lord, I have a tight game, my lord. If I'm available, I'll definitely be here.
Then we'll post it some other day. then.
Yes, that will be better. Let it be on Monday next, my lord. Monday, good, right? Monday. Oh. Remind. Tuesday to anniversary.
Tuesday.
Can you take it up on Monday?
Tuesday.
Tuesday, one.
Tuesday.
Lots.
All right. This IA was fixed today with the consent of Learned Counsel for the parties, but when this matter is called up, some of the Learned Counsel have expressed difficulty in arguing the matter and have made a request for little accommodation. First up, in view of the above and with the consent of Learned Counsel for both the sides, this matter is directed to be listed again on 7/2/2023 as a fixed item.
Next time.
For admission,
But not pursuant when selection process, this 36 petitioners, they were appointed as dentists in the government of Assam.
Yes.
But their appointments were shown as 3M. However, my lord, they were paid the regular scale and all. We are continuing since then. Now, my lord, in
They were appointed when?
between 2011 and 2015. Then, my lord, in 2016, again an advertisement process was started by the department for recruitment of dentists. Now, my lord, for some reason which or to which we are not privy, that selection process was abandoned. Then subsequently, again in 2018, an advertisement was issued, whereby the post where we were, working, those were also put to my lord advertisement, sorry for a selection. Then we approached this honorable court with the prayer that to the extent of 36 seats out of the 71 posts advertised should be kept vacant and the rest may be proceeded with. And precisely an interim order was passed saying that 36 posts will not be filled up. However, I think I understand, my lord, government has not gone ahead with the selection in total. Now, my lord, our simple case is, now the state very often speaks of Umadevi, Umadevi, Umadevi. My lord, Umadevi has been understood and explained by the Supreme Court in at least 10 cases where, my lord, the position remains the same. My lord, if we had taken part in a legitimate process pursuant to which we were selected, and if we continued, then, my lord, we have a right to be regularized. If not, there is a scheme, we should frame a scheme. That is our basic case, my lord. As on date, we are continuing. Now, state would like to say, my lord, on one of the occasions, state has placed an instruction that they will provide us 25% weightage, and we should take part in the selection process. My lord, we cannot compete with fresh graduates. That part is an aspect which Supreme Court has already said. By dint of our age and all, my lord, we cannot match the abilities of a new recruit. And therefore, my lord, either we succeed in establishing our case or we fail. But there's no question of why we again participating in the selection process, that in a truncated manner. Some weightage.
So there was advertisement of this.
Yes, yes, everything.
Selection process was there.
In fact, my lord, lordship knows, and my lord, these are all sanctioned posts.
But
Then how does it violate Umadevi?
That it does not. That they often take the plea of Umadevi, that Umadevi will come to the rescue of the state. Rather, Umadevi will come to the rescue of us.
Then why was the appointment under 3F?
My lord, we as a person seeking employment, do we have any,
No. Any idea why the 3F appointments are made on temporary basis for 3 months, 6
No, my
months?
lord. Actually, my lord, there is a judgment of our High Court also, my lord, explaining the purport of 3F. Normally, in a post, if it is not likely to continue beyond 4 months, and the normal mode of selection is likely to take some time, in such a situation, my lord, 3F can be resorted to. That means consultation with the APSC can be dispensed with. But when the posts are, my lord, sanctioned, when it is a continuing for time to come, in that case, my lord, 3F does not apply. And merely because they have appointed as a 3F, lordship will examine whether it was a 3F appointment or it was an appointment as a substantive post in a substantive capacity. That would be my alternative prayer, my lord.
Mr. Bora, this can't be a joke.
Yes.
These are people, they are professionally qualified. They are working since last 10, 11 years. You advertise the vacancies, they apply, you conduct a selection process, then you appoint them against regular vacancies. So we'll have to presume that this expression 3F, we don't know what is there in the appointment, is a product of misunderstanding or lack of understanding
Yes.
of the provisions of the law by the authority who issued it.
Yes.
It has the trappings of a regular order,
But
order of regular appointment. So where is the question of 3F? Why, how can you discontinue them? The posts are there, their services are required,
yes, my
they
lord.
are being paid regular salary.
But for regular selection, the selection process has to be conducted by the APSC. So after conducting the selection process by the APSC, they recommend, my lord. But in the instant case, my lord, because due to some exigencies, my lord, the department has directly recruited the person. And in fact, my lord, some of the petitioners, they have been appointed on the basis of the recommendation by some MLA or minister, my lord. So 3F appointees, my lord, and the petitioners, my lord, in their appointment order also, my lord, it has been.
See, Mr. Bora, is it not little too late in the day to go into all these things? Think about these persons.
Yes, my lord.
What will happen to them now?
My lord, because of that, my lord, government took a policy decision that, my lord, the persons who have been serving under 3F, my lord, they will be given some weightage in the selection process. We have filed our affidavit to that.
But
effect.
still, some of them may not get selected.
Maybe, my lord, because, my lord,
That
some
will-
of
then
them,
they
my
will
lord-
have to examine the issue.
Yes, my lord.
Because if a mistake has been made, it has been made by the department.
Yes.
Why should they be made to suffer?
No, my lord, because while appointing them, they were well aware that it was a temporary appointment under 3F, my lord.
Hmm.
Appointment order also clearly states that. So while appointing the petitioner, they were aware of the fact that it was a temporary appointment for a period of 4 months initially, my lord.
Correct. That is in 2011.
2011, 2013, 14, 15, my lord. So
Right.
thereafter, my lord, the selection process, the due advertisement by the APSC was issued in the year 2016, my lord.
Hmm.
But that process could not be completed due to some anomaly in APSC, my lord. So thereafter, my lord, again, fresh selection process was initiated, my lord. And after that, my lord, the health department, health and family welfare department in the government, they have constituted a board, medical health and recruitment board. So ultimately, in the year 2018, my lord, because the process was continuing, my lord.
Where is the advertisement, original selection?
That
All
advertise-
of them were subjected to a selection process.
Yes, yes,
No, no, not all of them, my lord.
all,
No, my lord.
my lord.
All of them were not in fact selected, my lord, in the selection process.
My lord, one such appointment order is at page 22 of the writ petition. Subject to discharge without assigning any reason thereof and pending receipt of police verification report, the following doctors are hereby appointed as dental surgeon under regulation 3F of the APSC limitation of function temporarily for a period of 4 months in the scale of pay of rupees so and so, plus other allowances as admissible and posted in the health institution as shown against their names. So, my lord, there are different orders are there. We have annexed. I think the appointment orders runs up to page number, my lord, 29. In fact, my lord, this post were already created and sanctioned earlier. That is why in 2016, my lord.
But why have you made 3F appointments against sanction posts, vacant posts?
Exactly, that is the point.
What is the logic behind it? Tell us that. You can't misuse 3F, even if it is the government, you can't do that. The purpose of 3F is very clear. It is to tide over a temporary, exigency.
Yes, my lord.
But when there are vacant posts, sanctioned posts, you are issuing advertisement, you are holding selection, then why 3F?
Because, my lord, otherwise department cannot make the selection. They have to appoint on the recommendation of APSC only, my lord.
Hmm.
So since there was urgency, that process could not be completed. That's why, my lord, department without recommendation of the.
No, why they cannot make, where is the bar?
My lord, because as per the rules, my lord.
Hmm.
So APSC has to recommend, my lord. The selection process has to be made by the APSC, my lord.
Did the government approach the APSC?
No.
At that point of time, they did not, because there was some exigency, so they did not have time or.
Anyway, Mr. Bora, these are all internal departmental matters. We are concerned about the impact your decisions will have on several households. You see, the court cannot be oblivious about the impact of a decision. You might have done it for this reason, that reason, but if a candidate, if he comes to know that these recruitments are to be made against sanctioned vacant post, a proper selection process is followed, and then appointment orders are issued, then how does it matter to him whether APSC should have done it or government should?
Because You was also aware of that it was a.
Is there anything which says that unless APSC recommends the appointment will be illegal?
There's nothing, my lord. In fact, there is a judgment of this honorable court, my lord, in a similar circumstance. Such an appointment has been held to be, my lord, a regular appointment. Though it was described as 3F. Because it was against a sanction post and it was preceded by a selection. Even Umadevi says, my lord, that if the selection is by following some procedure of law, then my lord, then we are entitled to the benefit.
And if it is against sanction post,
Yes,
the post is not there, nothing can help.
yes.
But if the post is there,
And in fact, my lord, in one of the judgment, Honorable Supreme Court has said, my lord, this is an alternative mode of appointment. It is not an illegal appointment. Because of the administrative exigency, sometimes state may resort to an appointment which is consistent with Article 14, but may not be strictly in accordance with the prescription of the recruitment rules. In such a case, Supreme Court has said it will be an alternative mode of appointment. I brought the judgment, my.
so the matter will have to be heard then.
It has to be heard.
Your lordship may once prove that, yeah, it may be hard, my lord.
Heard Mr. K. N. Chaudhary, senior counsel, listed by Mr. J. Patori, appearing for the writ petitioner. The petitioners herein are all dentists, within quote, dentist by qualification and have been appointed against sanctioned vacant posts of dentists under the
Different health institution of this.
in different institutions coming under the government of control of the government of Assam during the period from 2011 to 2015. Full stop. Their initial appointment was under section 3 of the APSC. What is that APSC regulation?
Limitation of function regulation 1951.
And
No,
their
no,
services were continued from time to time. However, after several years of service, the petitioners were asked to participate in a selection process, which also did not materialize. Selection process to be conducted by the APSC, which process also did not materialize due to reasons discernible from the materials on record. Be that as it may, the grievance of the petitioners is that at this distant point of time, they cannot be made to compete with fresh candidates and participate in a new selection process, as such a recourse would be highly prejudicial to their interest. First up, Mr. Chaudhary, then as senior counsel for the petitioners, also submits that once it is found that the appointments were made against sanctioned vacant posts and pursuant to a proper selection process, merely because APSC was not involved in the recruitment process, that would not make the appointment of the petitioners illegal. First up, it could at best be a case of irregular appointment, which can be rectified, regularized by the government by following due process. First up, therefore, there cannot be any question of discharging the petitioners at this belated stage and compelling them to subject themselves to a fresh recruitment process. First up, Mr. Bora, learned Standing Counsel Health Department submits that the petitioners were aware that their appointments were under section regulation 3F and was temporary in nature, and therefore the stand of the petitioners are untenable in record. First up, the learned departmental counsel, however, submits that the petitioners are continuing in service on the strength of interim order passed by this court, and therefore this matter be posted for regular hearing. In view of the above, admit this writ petition. Since the respondent is already present, no formal notice is required to be sent to the respondents. Full stop. Register to list this case for hearing in usual course. Interim order passed earlier to continue.
My lord, in terms of interim order, we are not continuing, my lord. By interim order, 36 posts were directed to be kept vacant.
Still continuing in service.
Yes.
Interim order part na lage. It appears that there is also an interim order from this court directing that 36 posts of dentists be kept vacant. full stop. Therefore, it is apparent that the writ petitioners are holding, are serving against those 36 vacant posts
Yes.
as on date.
36
Full stop. So and so, so, baki kine ek rahi wo. Usual posts.
Deep level.
At a line no, there is no application for vacating. No, it won't like.
Item 4. No, please, Lord. What's it on last occasion, Lord? What's it? For some information, Lord, whether those order passed by the county court has been complied with. Yes, I have made a list of candidates. Lordship, this is the list, Lordship, who has applied for compensation employment under forest department only, Lordship, or in other department. And those, in those cases, Lordship, I have given 25 number of cases, Lordship. I have applied in all those cases, Lordship. And case number 1 was the first case, Binarabi. Subsequently, she has been appointed, Lordship. Then Manoj Das, Lordship. He is also appointed. Up to Lordship, case number 13, all applicants have been appointed subsequently, Lordship. And from 14 to Lordship, 23, all are under process, Lordship. And 24 is also appointed. So I am giving a list to my running friend also, Lordship. He will verify whether those persons have been appointed.
Verify and then
Yes,
come.
Lordship. Lordship.
Mr. J. Kalita, learned counsel for the petitioner, has furnished a list of cases along with the orders passed therein by this court to submit that the cases of similarly situated persons have been considered by the authorities on the basis of the order of the court, and therefore a similar order is required to be passed in the present case as well. Mr. R. Gogoi, learned standing counsel, Forest Department, Assam, 10 days time to verify the orders and make appropriate submission before this court. In view of the above, let this petition be listed again after.
Lordship.
All right.
You have-
Item 5.
Sorry, I did the same.
Similar.
Similar.
4 and 5, same.
Lordship. Okay.
Item 6.
Lordship, where is the last order, Lordship? That is 112, Lordship. I has asked to produce inspection whether he has submitted any undertaking or not.
Undertaking regarding what?
He has given an undertaking, if his performance at Tajikistan was not, he will be repatriated, because that was the term of the condition of his transfer. That will, Lordship will find in our affidavit at page.
May I submit? Yes, let him.
With due respect, I have.
One minute, let me just see what is there here.
The last page, I have given a type copy also, the undertaking. Third page is the original downloaded copy, Lordship.
So what has happened? The petitioner has been
Lot number,
reported.
lot number
Can hear you, just a minute, yes. What has happened? The petition was sent to Tajikistan.
Yes, sent to Tajikistan, but there was there was earlier 3 occasions he was warned. That are all have been stated in the justification order.
Just a minute. Don't start with the particulars.
No.
Give the facts first.
He was transferred there, then his.
Who is he? He's a
He is a
doctor.
cook. He is a cook.
He's a cook. Cook under whom?
Cook under the border roads, Lordship.
Yes. So what has happened? He was
Is
sent to Tajikistan.
Tajikistan
on
for a
duty.
project, Lordship, project work. Lordship.
Correct. Then what has happened?
He was earlier on 3 occasions, Lordship. Then he was engaged in a brawl with one of the colleagues. Then there's
These
decided. to
are
send-
particular, Mr. Chakraborty. After
So he
many-
transferred, we.
let us understand what is a fact and what is particular.
He has been transferred back to
He's been transferred back to India.
Sila Pathar and.
So
posted
that
at
order
Sila
is under challenge.
Pathar. No stay order has been passed.
Yes.
Its order is of 21, Lordship, May 21. no stay at work.
So
Whether
he
he,
is back now.
he's back now, he has joined here, whether he can be, we can put the clock anti-clockwise backward also, Lordship. Whether he can, again, someone has joined there in his post, Lordship.
So what can the read court do in this matter? Yes.
With due respect, I humbly submit, my lord.
Hmm.
But there are two projects of Borders organization. One project in Tajikistan and another project is in Bhutan, my lord. Basically, the person is selected on merit cum seniority. It is basically in merit, rigorous selection procedure is there. So this cook, he was selected through due process of methodology and posted. What happened, my lord? And I'll answer the so-called undertaking and contradict it subsequently. What happened, my lord? There is certain once he could not cook the food properly, my lord. So they ordered an one-man inquiry, not even a court of inquiry, not even this is a board of officers. He was not given a chance to cross-examine any witness, not to depose himself before the inquiry. So, my lord, unilaterally, they warned him as a form of punishment, recordable warning, my lord. So, I draw my lord's attention to the recordable warning page, my lord. That is page 13, annexure 2. I read, my lord. The one-man inquiry in the recommendation, void letter number 4001 OMI, parts 01E1, have directed to issue warning letter to you for creating unruly situation in the dining hall, disturbing the discipline on 21st April 21, my lord. Your unruly behavior, by which you argued with the mess commander and also leveling false accusation on him, is a serious breach of rules of conduct, my lord. You are hereby warned to be careful regarding your behavior and not to repeat the act in future, my lord. So this is the warning they have given, my lord. But my humble question of law in this subject matter, they did not, they could have resorted to Rule 14, Rule 16, they could have resorted to one court of inquiry, giving an opportunity under Rule 180 of the Army Act. What they did, my lord, simply they posted him out. So, my lord, I appeared before this honorable court, and now I draw my lord's attention of honorable court's order dated 25th August 21, my lord. For a moment, my lord, from second para I read for my lord's convenience. 25th August 21.
Yes.
My lord, the learned counsel for the petitioner submits that the transfer was penal in nature because the tenure of transfer and posting to Tajikistan of 2 years, projecting that the transfer was a penal in nature. He has referred to the case of Somesh Theory versus Union of India and others 2009 to SCC 592. My lord. This Honorable Supreme Court laid down the law that that penal action cannot be a substitute for transfer, because if transfer being an incidence of service, it cannot be resorted to as a method of penalty. So, my lord, subsequently, this honorable court was pleased to note that keeping the issue of territorial jurisdiction open, let a notice including notice on the pair of interim relief be issued returnable on 24/9/21. It is provided that the present place of transfer of the petitioner would be subject to further order that may be passed by this court, which I stress upon. my lord, his posting, my friend he wanted, my lord, I draw my lord's attention to page 17 of my petition.
Yes.
He is an illiterate cook. And in the page 17, I read in the meet period, my lord, after a few lines, I humbly request that I am Chandravani Sharma Cook, came to Tajikistan on 7 November 2020. Sir, I have greatly harassed. I have been given 3 warning letters, got posting order done. I made a prayer to the disciplinary action, sir, that I had no fault, but they did not agree. Gram remains uncooked, although it was nice, but court of inquiry was set up as one-man inquiry. He says, I should have been given a chance to depose and to examine and cross-examine. So even an illiterate cook is writing, my lord. Earlier, May Sabildar Carpenter Gajendra Singh used to abuse me verbally several times. And later on, when he hit me, I gave an application to the commandant, sir, that he should not repeat the same mistake again and he must apologize. But senior authorities instead blame me for the same and issue a 3rd warning letter and posted me. I asked for inquiry, my lord. An illiterate cook is asking for inquiry to prove the charge, whether there is a misconduct or not. And in front of whom I was beaten, they have also stated that Sharma has no fault, and in spite of that, I was punished. Said 25 years in foreign nation, children are studying, eligible for marriage, took loan from bank to build house, lots of responsibility. My family was happy that everything would be sorted out. I have also done my duty well. I cooked whatever they said. In spite of that, I do not know why they are offended and treated me like this in a foreign nation. But this is what he paid for. Then what happened, my lord? This they are now after this thing, my lord. They have the written reply counter has been filed. I draw my lord's attention to the
So
counter.
it is not, 1 minute, you have Mr.
Tapas Das, my lord.
Yes, we have seen it. You can't get a
Yeah,
whole
my
day
lord,
to
just
argue.
2 minutes.
Just another 5 minutes.
2 minutes.
You conclude in 5 minutes.
2 minutes.
Yes.
But at page 3, I draw my lord's attention to the counter.
Hmm.
In the page 3, they have stated administrative reason.
Hmm.
In para 3, they have administrative reason. So on what reason transfer means? On administrative reason, incidence of service. Page 3, para 3, my lord. I'll take 2 minutes time.
Yes, yes.
Right, my lord? Then I draw my lord's attention to annexure R5, page 17. R5 of the counter affidavit, page 17, my lord. Page 17, annexure R5. The case, may I read, my lord, second para?
Yes, yes.
The case regarding repatriation in GS number 1785418, Chandrababu Sharma project IDET to on disciplinary ground has been examined as this directorate. So, my lord, I humbly submit. In the counter, they say it is administrative ground. When they post me out, they say on disciplinary ground. So it attracts the Supreme Court order, which says that a posting cannot be resorted as a penal measure. Now I draw my lord's attention to page 18, lastly, my lord. Again, page 18, next page, my lord, annexure R5. Statement of case for repatriation of disciplinary action in respect of following case is forwarded herewith for your necessary action. So every time, my lord, they say it is a case of discipline misconduct. But in the counter, they have twisted the matter, saying no, it is a administrative ground, is an exigency of service incident of service. So my lord, I am relying on the Supreme Court order, Somesh Theory versus Union of India, 2009-5922, and I humbly submit why they have done so, my lord. Because it is one vacancy is there. Only the cook, which was serving the commander, who is the authority to post, has replaced this individual, my lord. He has got a marriageable 2 daughters, sons. And
He is out of work.
No, lordship, he is working, he is posted in Silapathar, he is working.
But he has been sent back, my lord, without even he represented without.
And his
giving-
statement is not in the.
Just a
pleading of
minute,
his
just a
writ
minute,
petition.
please, just a minute. Without giving a hearing, he has been thrown out from the unit. And immediately, that person who was working in the
Who is the
commander,
head of this organization?
Director General Border Roads.
So we'll ask him to file a representation before the Director General Border Roads.
My lord, they will throw it out, my lord.
Can't be helped. We can write a 15-page judgment. Submissions you made, I can delete in 5 minutes. This is a foreign
There is a
assignment.
Supreme Court judgment.
This is a foreign, even if the court says send him, he has to get a visa, he has to be processed.
Visa is there, everything is there, my lord.
No, these are different things. On a technical ground, you may be correct. We may observe that this cannot be a stigma, etc., etc. There is a reason, there is a ratio of these decisions. The punitive transfers are not permissible because it becomes a stigmatic.
Stigma, yes, my lord.
We can remove the stigma, but there can't be an order directing them to send you back. That you will not get from this court. You want to argue, you argue.
But my lord, my humble submission, let there be not a cryptic mechanical order, let there be a speaking order. If he is agreed, let him come to, with the liberty to file a faith petition. Because they normally, is being an army sending organization, they receive it, they make a just type copy of that and dispose it off. So every time the court.
Who is the authority? Let somebody look into his grievance.
Right,
These are actually intra-organizational. These are not matters. The
I
lead
agree,
cook
my
can
lord,
go so
but
deep.
it's-
Who is the cook? What was his behavior? And
Also,
where he should be
There should have
working?
been an inquiry. That was the humble submission of the cook. Before sending me, hold me an inquiry. If I'm guilty, throw me out from the service. Not even posting.
No, these
Remove.
are all arguments can
Yes,
be
my
made,
lord,
but then
I humbly
these
submit.
are
my
not
lord.
practical.
I humbly submit, my lord.
If some cook, assuming that it's correct,
Yes, my lord.
what do they do? You would expect them to throw you out of service because of that. That would have been a better choice. How can it be, Mr. Das?
My lord,
And it is not that.
I leave it to my
It is
lord's
not-
discretion.
The fact of the matter is that he was earning some extra money.
Yes, my
He is
lord.
agree because of that.
That's
Yes,
all.
my lord.
That's the point. We
Yes,
also know what is it.
Yes,
But then these are all, you see, chance postings.
Yes, my lord.
Some people are sent on abroad assignment. As long as they stay there, they draw dual salary. One in India and one abroad. So that gives him a lot of financial benefits.
Yes.
Somehow he has invited the ire of his superiors and they have sent him back.
Yes.
What do you expect the Reed Court to do on that?
Yes. My lord, I leave it to my lord's discretion. Whatever the order passed, it is, I humbly accept it.
We can't issue a mandamus that
Yes.
no, you send him back to
Yes, my lord. I,
Kazakhstan and
I
let
agree.
him stay there for another 5 years.
yes.
Till such time his loan is repaid and his daughter is married. We expect an order like that.
Yes.
How can that order be passed?
Deeply of.
Who's the authority? Tell us. Who's respond number? Has this representation been disposed of?
No, my lord. They are-
Page 17. DGBR. Page 17, annexure 4 of the writ petition, has it been disposed of? Dated August. Has it been disposed of?
No, my
Perhaps not, perhaps.
All right, heard Mr. T. You're Mr.
Tapas dance, my lord.
Tapas Das. You are from Guwahati or you come from?
No, my lord, I filed, I'm from outside, outstation.
Mr. T. Das, Learned Counsel, who has appeared on behalf of the read petitioner. Also heard Mr. B. Chakravarti, Learned CGC, appearing for the respondents. Full stop. The read petitioner hearing is serving as a cook under the GREF. Is it GREF?
Yes, my lord.
General Reserve
Engineer
Force, bracket GREF, and is presently posted at Silapathar. Full stop. Earlier in the year 2020, the petitioner was sent on an overseas assignment to Tajikistan in EYE, capital EYE, all of gap diplomat DAT-2 as a cook. Full stop. However, while rendering his services as a cook, it appears that there was some incident which had invited the ire of the authorities therein. Full stop. It was felt that the petitioner, it was felt that the petitioner's conduct was unsatisfactory. Full stop. It also appears that an one-man committee inquiry was conducted into such conduct of the petitioner, whereafter he was repatriated back to India by impugned order dated 25/5/2021. Full stop. The grievance of the petitioner is to the following effect. Stop. Firstly, that if there was actually a case of misconduct, then the authorities ought to have taken disciplinary action against him by following the, what is the manual?
Lordship, he says CCS rule ought to have been
By
followed.
following the CCS rule 1972, which has not been done in this case. Secondly,
1965, my lord, if I,
CCS rule 1965.
yes, my lord.
Is there a CCS rule 1965? Check it. Where have you got the rule?
No, my lord, I don't have, but it is 19.
By following the disciplinary rule applicable in this case. Full stop. Secondly, the transfer oblique repatriation of the petitioner from Tajikistan to India on the basis of the one-man committee report is nothing but a punitive transfer and casts a stigma on the lead petitioner. Full stop. Therefore, the same was untenable in the eye of law. Full stop. By referring to the decision of the Supreme Court rendered in the case of, which is the judgment? Somesh Tiwari.
Yes, my lord. Somesh Tiwari versus Union of India,
versus
2009.
Union of India and others reported in 2009, bracket close 2 SSC 592. Mr. Das submits that a penal transfer of this nature is wholly impermissible in the eye of law. Full stop. On the aforesaid twin grounds, the writ petitioner is seeking an order from this court directing the authorities to send him back to Tajikistan so as to enable him to complete his tenure. Full stop. Responding to the above, Mr. Chakravarti, Learned CGC submits that the petitioner has already been replaced by another
And he has
competent,
went under it, giving an undertaking also. Lordship may report
competent
that
cook,
also.
and therefore at this stage he cannot be sent back to Tajikistan. The Learned CGC has also produced a copy of the undertaking, written undertaking given by the petitioner at the time of
Which is as per clause 5 of the.
commencement of the assignment at Tajikistan, whereby he has agreed that if his performance was found to be unsatisfactory, then he would be liable to be repatriated back to India. First up, insofar as the allegation of disciplinary,
For other submission, I relied on 3 decisions. The transfer is subject to same amount of scrutiny like the dismissal and termination.
insofar as the other arguments advanced by the petitioner's counsel is concerned, Mr. Chakraborty submits that even an order of transfer in the matter of overseas assignment would be subject to, would be preceded by similar level of scrutiny as in case of a disciplinary proceeding. And therefore, in the present case,
Will not be subject to same amount of scrutiny,
will not be subject
judicial
to
scrutiny.
an order of transfer in and out of overseas assignment would not be subject to similar nature of scrutiny
As in the
by
case
the
of
court,
dismissal or.
as in the case of an order imposing penalty upon an employee. And therefore, the submissions made by the petitioner's counsel were untenable in law. According
And the
to
other
Mr.
case is that
Chakraborty-
LK Singh's case, Lordship.
According to Mr. Chakraborty, since the performance of the petitioner was found to be unsatisfactory, he has been repatriated back to India. First of the learned CGC submits that.
In such
We-
cases, intention is not the motive. but
No,
only
no,
foundation.
forget it. Mr. Chakraborty further submits that the petitioner is still in service and he is drawing his regular pay and allowances. First of therefore, there has been no violation of the terms and conditions of service insofar as the petitioner is concerned. First, I have taken note of the submissions made by learned counsel for the parties. First up, there can be no doubt about the fact that in case of an overseas assignment, a completely different procedure as compared to a normal tenurial transfer inside the country is to be followed. First up, moreover, when an employee is discharging his duty overseas, he may be required to follow stringent norms of discipline and performance, which only the superior authorities will be in the best position to judge. Full stop. However, judge, in the present case also, it appears that the authority superior to the petitioner were not satisfied with his performance. Hence, he was repatriated. To that extent, the petitioner, since there is no violation of condition of service of the petitioner, hence this court is of the opinion that the petitioner cannot raise a grievance against such action. Full stop. The grievance of the petitioner can, however, be maintained if it turns out to be case of mala fide exercise of power, or where the transfer turns out to be stigmatic. Full stop. Since there are materials to suggest that there are observations as regards the conduct of the petitioner leading to his repatriation, and considering the fact that the representation dated
1st August 21.
1/8/2021 submitted by the petitioner before the DGBR, that is respond number.
DGBR is not a party, Lordship.
DGBR, full stop. Without expressing any further opinion on the merit of the claims and counterclaims of the parties, I dispose of this writ petition by providing that the grievance of the petitioner, as highlighted in the representation dated so and so, be looked into by the DGBR or any other competent authority nominated by him, and the same be disposed of by a speaking order within 90 days from the date of receipt of this certified copy of this order, after giving an opportunity of being heard to the petitioner. Full stop. If it is found that the observations and remarks in the record are stigmatic and may prejudice the interest of the petitioner, necessary steps be taken for expunging the same from the record. With the above observation, the petition stands closed.
My lord, one humble son, he was posted out on disciplinary ground. He was posted not on undertaking, based on disciplinary ground as per their annex.
This order would, however, not come in the way of the authorities in initiating fresh disciplinary proceeding against the. Mr. Das, why are you insisting? They can throw you out of the service.
Yes, sir.
And rest of your life, you will be, moving around the courts.
Yes.
I should not be saying this.
I apologize.
Don't show so much of ego.
I apologize.
Don't show so much. He's a cook. Let him survive. These are different nature of assignments.
Yes, ma'am. I apologize.
We can ask them that if they want to proceed, they should initiate disciplinary. You want that order?
No, I
You want
apologize. I
All right,
apologize.
all right.
Deep-
Just a line to Nalagi.
Deeply on that, madam.
Item 7.
My opinion, Lordship. Lordship, in this case, we are directed to take instruction, Lordship, whether the petitioner is entitled to any pension or not. Lordship, instruction not received, one is going to be granted, Lordship. Since it is not prayer in the repetition.
Heard Mr. R. Mazumdar, Learned Counsel for the petitioner, also heard Ms. R. Devi, Learned CGC, appearing for the respondents who submits that instructions as called for in terms of the order dated 24/1/2023 passed by this court are still awaited. In view of the above and on the request of on the request of the Learned CGC, this matter stands adjourned. Hearing of this matter stands adjourned for another 4 weeks, so as to enable her to obtain instruction. 3 weeks will mean 8 weeks, because after 3 weeks, if she doesn't get it, after 2 weeks, then we'll adjourn it by another 4 weeks. What do you want?
But what I was trying to say is that if they do not have the instruction, the matter can be heard. That is what I was trying to say. Because
You want it to be recorded.
My lord,
If the respondent counsel fails to obtain instruction even on the next date fixed, the writ petition will be taken up for hearing and final disposal on the basis of materials available under.
I'm obliged.
Yes, sir. The cooker.
Item 9.
Admission hearing, and admission hearing.
May I please? This is the second round of litigation in respect of a compassionate appointment. Lordship, may kindly see the order passed in the first round of litigation at page 38. This was the order passed by the Honorable Court in the first round of litigation. Para 5 may kindly be seen. In view of the above, the present
Page number?
page number 38, my lord. To consider the case of the petitioner for appointment in harness scheme by examining the ability of vacancy in other departments as mentioned in the above mentioned OM. Above mentioned OM dated 1/6/15, which exercise shall be undertaken by the authority in the next SLC meeting within a period of 3 months from the date of this certified copy of the whichever is earlier. The petitioner may be informed accordingly as a result of the same. My lord, what have they done, my lord, may be seen at page 42. The SLC in its meeting held on 23/12/2019, my lord, without examining the availability of post as per direction of the Honorable Court, simply a ground of rejection has been given. Application of the appellant was pending for recommendation for more than 3 years, therefore application is to enter court. This is not tenable, my lord. This is contempt charge also. They have to examine the availability of the, then they can dispose of the matter, my lord. And so this petition is being filed to consider the case of the petitioner afresh, my lord.
On last 2 occasions also, your lordship, some instructions were directed to be obtained by us as to whether some rectification process or something else can be done. Unfortunately, no instruction has been received by us, your lordship, but the fact still, it does appear that your lordship prima facie that what my learned friend is saying does have some force. It could be that if it falls from your lordship, that the matter is again remanded back to the SLC for consideration in terms of the order. That can be done.
It can be go to the DLC, my lord. Proper steps will be, it will be appropriate to send the matter to DLC, my lord, instead of SLC. State has filed a 2 review petition, my lord, which were allowed, directing to reconsider the case of the other petitioners in that petition by the DLC. Because the
But
SLC,
DLC has recommended your case.
my case was recommended.
Then why
by the-
should it again go back to DLC?
My lord, it is their case in the, I filed to.
Why should it again go back to DLC?
It is up to your
DLC,
lordship.
then we'll say that it will be open for DLC not to recommend your case.
My lord, this is up to.
You are
lordship.
agreeable to that?
I leave it to lordship.
Mr. Bhattacharya, when you make a submission before the court, there
Right.
should be some application of mind. Is
Well,
it not? When you make a submission before the court, some application of mind should be there.
My
What
lord,
say?
my prayer is to set aside the order
Hmm.
and give a fresh direction to the.
No,
SLC.
DLC has considered and recommended your case.
My lord, not in other departments, my lord.
SLC rejected it.
No, my lord, there is. another-
Listen to me.
My lord,
You don't know your facts.
my lord,
DLC has recommended your case.
my lord,
SLC did not consider.
my lord,
You came to the High Court
my lord,
by filing the earlier writ petition.
my lord.
High Court says, examine the vacancy position, consider his case by the SLC and take a decision. SLC does it, but holds that because it was 2 years later, so the application has spent its force. That's how you are aggrieved. Why do you want the matter to be sent back to DLC again?
In fact, I am not want to get the matter to the DLC.
Yeah, just now you said,
My
did
lord,
not say.
just a minute, just a minute. This type of order passed in several repetitions, my lord.
Hmm.
In some cases, I file in number of 2 cases, I file contempt. It is a contempt case, my lord. It is altogether a contempt, my lord.
Hmm.
The state come and says before the honorable court that we will file a review application before this honorable court because there is some SLC is not considering under 15 in other departments, my lord. So they filed a review application and honorable court allowed that. On that strength, I am submitting because lordship is not aware of those facts, my lord.
No, but why don't you file a contempt case? Here,
Here it was late, my lord. It was not come in time, my lord. It is after 1 year, my lord. So I think in that case, lordship has issued the notice, my lord. Lordship might have forgotten this during the time of pandemic. my lord.
we don't keep personal record of which case notices.
Anyway, my lord, anyway, this reserve disposal.
Dismissal, not disposal.
My lord, it is up to your lordship.
You give me the reason why the same order is to be passed again. The court has already passed an order saying that consider the vacancy, examine the vacancy position and consider his case. They have not done it. You now want the court to again pass the same order. Is that so?
I have no option, my lord. What can I do, my lord? I have to come to the honorable court to look into the matter, to appraisal of the honorable court. Look, this is the case, my lord. A poor boy cannot run after the mighty state, my lord. He is the only option to come before your lordship.
Yes.
In that case, the earlier orders that were passed for rectification, perhaps maybe the honorable court was also thinking along the same line, just how the same order can be passed. Let me get the instruction if there is some rectification, something can be done, your lordship. If an order is passed with some observation as to why this instruction has not been received, I'll get the instruction within 2 weeks, your lordship. Otherwise,
Heard Mr. D.N. Bhattacharya, learned counsel for the petitioner, also heard Mr. C.S. Hazarika, learned government advocate Assam, peruse the averments made in the writ petition. It appears that despite the categorical direction issued by this court by order dated 27/5/2019, passed in WPC number 3363 of 2019, directing the SLC to examine the vacancy in the other departments as mentioned in OM dated 1/6/2015 and thereafter reconsider the case of the petitioner for appointment under the within course die in harness unquote scheme the petitioner's application was disposed of merely by observing that the same was barred by time. Full stop. Perusal of the SLC, a perusal of the minutes of the SLC meeting held on 23/12/2019 clearly goes to show that there is a willful and deliberate violation of the direction issued by this court. Full stop. The learned government advocate Assam also expresses his helplessness by submitting that instructions as called for have not yet been received. Full stop. Under the circumstances, the only option left for the petitioner is to file a petition alleging contempt of court. Full stop. It appears to be a case of continuing contempt since the respondents have continuously failed to comply with the court order. So at this stage, you file a contempt case with at this stage, Mr. Bhattacharya seeks 2 weeks' time to file appropriate petition alleging contempt of court. First, a prayer allowed. If such a petition is filed, the same will be taken up for consideration along with WPC number 4817/2021. Let these matters be listed again. Let this matter be listed again after 3 weeks. If file a petition, we'll tag it and we'll see.
My
We have
lord, it will, some more time would be required as the chairman has already been retired.
How much time you want? 4 weeks.
Chief Secretary, Mr. Sanjay Krishna was got that time, my lord.
It's a 4
at that
weeks.
time.
We can make it 4 weeks.
May I,
Mr. Bhattacharya, you take the proper recourse under the law, then only we'll be able to catch on. Because this is a case of contempt.
this is a case of.
The law is clear. Second writ petition is not maintainable when it's a case of contempt. Therefore, this court cannot pass an order knowing
My
fully.
lord, my lord.
Only option
Because
is-
at that time, Lordship is opined that this is a fresh cause of obstruction.
No, what is
also-
it? Then you show me what is
No,
that you are
no, my
referring to?
lord, no, my lord, this is a verbal observation, my lord, I am not. So I filed a repetition because it is not one time, maybe the Lordship is observed is a continuous wrong, then I will file a,
No, I'm not dismissing your writ petition.
no, my lord.
We'll take it up
Alright.
along with the contempt also.
My lord.
First, we'll have to ask.
They
the-
are taking time after time, my lord.
Lordship, I also agreed. Lordship, one instruction was received in earlier, prior to the last orders that whether rectification is there or not. So your Lordship has said, expressed my helplessness regarding the instruction. One instruction in August 2022 was received by me. So perhaps that is, otherwise they will say that why did you not place this instruction? That is not very helpful because they are only saying the same thing that what SLC has done. Some
Expressing
slight-
his helplessness in placing any updated instruction and submits that the last instruction received by him was on
5/8/22.
5/8/2022. 5/8/2022, which does not throw any light on the contentious issue raised in this.
Lordship.
You have not dismissed your writ petition,
My lord.
but we have to know why they have not complied with the court order. Then only we'll pass further orders. So you have to file a contempt case.
Lordship, I'm so sorry for 25 August, not 25 August.
August 2020.
I'm so sorry.
2022 is the date.
Yes, 2020.
All right.
Maybe judgment, date good time for transmission, especially the record.
Sorry.
Earlier occasion we paid because Lordship, all the records of DPS in the Hindi Lordship. So honorable courts, we have taken permission to assist the court by one of our officers Lordship.
Hmm.
So Lordship may give another date today, they are not able to come Lordship. The whole records of the DPS in Hindi Lordship.
Heard Mr. I. Chaudhary, learned counsel for the petitioner, also heard Mr. K. Google, learned CGC appearing for the respondent who submits that the records of the disciplinary proceeding are all in Hindi. And therefore, an assistance of a competent officer
Lordship.
serving under the respondents, conversant with the facts of the case, would be necessary for conducting the hearing of this case. On such ground, Mr. Gogoi has prayed for posting this matter again after 4 weeks. Since the prayer is made with the consent of the other side, same stands allowed. Register to list the matter again on 27 to
What?
2022
What's it? What's
as a fixed item.
it? Second two. Thank you.
Item 11.
Milord, the petitioners were finally rejected from the merit list from the for appointment to the post of junior engineer. At page 36, Lordship will kindly come to. These post junior engineers under the Panchayat and Rural Development Department. 344 posts were advertised. And there 35 posts were reserved for EWS, economically weaker section. The petitioners belong to economically weaker section. They applied. They were taken through the entire process of verification. That test and all. And ultimately, they published a final merit list. Showing the aggregate marks at page 66, Lordship will find. I will take your Lordship to other points later on, little later. Annexure 11, page 66. This was the merit list showing the marks that was pursuant to an order of this honorable court by collateral banks. Order dated 29/6/22, which appears at page 63. Because they are required to, under the rules, to publish the merit list showing the marks on merit. They have after that direction, they have issued this. And here, Lordship will find roll numbers, name of the candidates, gender, category.
This selection process was carried out by APSC.
APSC. It was carried out by APSC.
You have the records?
Let's say I have filed affidavit in opposition. Record is not available to Lordship. I
Record-
file affidavit, Lordship, in my affidavit, if Lordship, affidavit filed by.
So, Mr. Mahanta, will the records be necessary?
Reports may not be, because I have placed all that, Lordship will see. Certificates are questioned. They say that the certificates which we submitted, those were not proper. That was the only ground they have asked. It is not denied that we secured higher marks than the last one who was appointed. Indeed,
Why the certificate was not found to be proper?
they say that they have two stands. They say that these certificates should have been in the particular year in which the advertisement was issued. They simply said, no, it should have been prior to the date of advertisement. Financial year prior to the year in which the advertisement was issued. That was basically the case.
All right, so now there were 344 vacancies.
344. Out of that, they filled up 322 or something like this. Ultimately, 320 because 24 posts were subsequently kept apart by an order of this one.
Actually, there is an order.
20 posts were ultimately
So
filled up.
interest of your clients are protected.
Yes. No, those posts are in different manner. My case comes within that 320 post, which was. Huh? Belak pe, sir? Here we have an order
We have an order, education. Yes, we have an interim order. And it says, my lord, the order dated 19/9/2022.
Just
Initial
one
order,
minute, just a minute.
yes,
19,
19/9/2022.
yes.
Last paragraph, any selection or appointment that may be made shall be subject to the decisions that may govern the present petition, and all such appointments, if made, be made subject to the outcome of the present petition, and the appointments orders to specifically mention that the appointment should be conditional. That was
So
the-
if you succeed,
Yes.
some of the candidates who
We
have
have
been
to-
appointed, they will lose their job. But they are parties in this proceeding.
No, we have come before making appointments. That is why this order was issued, that if you appoint anybody, then it should have to be conditional. Else you may not. That was indirectly told to them. They will have to be at the risk. It was prior to the appointment. Yeah, I don't know how many have been appointed now. They will be able to say. But when we
No,
came.
but at least in representative capacity, you will not have to impede anyone.
My lord, in
Then
my
even if
opinion-
you succeed, this order will be set aside at the highest court.
No, my lord, what I find.
No, you are right.
Yes,
This rider may be there,
yes.
but this rider doesn't say, and they will not have to be heard also if an adverse order is. That is not the meaning of this order.
No, not at all. But then their cases will be definitely represented by the authorities. They are supporting them. If going by the order of this honorable court also, and being aware of the fact that challenge has been put.
Achha, all right, we'll come back in 5 minutes. Please
Yeah.
think about it, Mr. Monta. This is a very, very,
My lord, so far lordship suggestion is concerned.
there is no suggestion.
My lord, no,
Just
that
flagging
regarding
this
requirement of law
Hmm.
to make them necessary parties, treat them as necessary
Yes,
parties.
you see, if the order was that
Yes.
keep 7 posts vacant,
Yes,
then the matter was different.
yes.
Once they are allowed, even if it is subject to outcome, even then they have to be given a chance, or at least some of them in
But,
representative capacity.
Well, that is of course. That is invariably true. Had they been previously appointed, I have come later on. That is of course. But here is a case. Now suppose the challenge was raised, and thereafter, having come to know everything, the pendency of this petition, they have gone
So
ahead.
is there any authority
Well,
where?
let them, my lord, I do not dispute so far the proposition of natural justice, so far they are concerned. Obviously, they will be affected. Once lordship holds that we have been illegally rejected. Obviously, those we 6 or 7, if we all 6 or 7 come in, then from bottom of the list, they will have to make way for
Correct.
us.
So the bottom 7,
Yes, someone will have to go. So from that point of view. But then the.
think
whether
about
they have-
it. Just consider it. I'll be back in 5 minutes.
Yes,
And if you have a authority which says they need not be made party, then it is fine. Otherwise, it may be a little difficult. Consider it.
Malad, before that, before lordship rises, Malad, if they have the details who have been appointed and whether those appointment orders.
That we can
mentioned
ask
about
them to provide. That we can ask. them.
Whether they have mentioned in the conditions in the appointment letters. If they
You see,
provide us,
that we can ask them to provide,
Yes.
but you see what happens is,
I understand.
they
but-
cannot come and say that, well, we have already been appointed, so this writ petition, that they can't say,
Yeah,
because there is an order.
Yes.
But this is one thing, and to say that they need not at all be heard, that is a completely different thing.
Malad, first let them provide me all these things, then I will look into it.
You tell us,
Page
give them,
66, Lordship, from that he can make party.
no, but what about their addresses, etc.?
So that can be provided, but in that page 66, there is a name and the last.
Cannot, because they have forwarded the list to the government. Now, whether government PNRD has implemented it, they have issued appointment letters for now.
Who is for the PNRD?
Not yet.
You see, if these 7 petitioners succeed,
6.
they would be displacing 7 candidates already appointed. So You have to furnish them the names of the 7 candidates from the bottom in order of merit.
EWS.
Huh?
EWS.
EWS.
EWS, that is the category.
All right, take down, heard Mr. K. K. Mohantul, Senior Counsel, assisted by Mr. K. Mohantul and Counsel for the read petitioner. First of, the petitioners, 7 in total, have approached this court, being aggrieved by non-inclusion of their names in the final list of selected candidates for appointment to the post of junior engineer civil close under the Panchayat and Rural Development Department on the ground that the EWS certificate produced by them were not valid. Mr. Mohanto has argued that the ground on which their candidature had been rejected by the APSC is not tenable in the eye of law. Full stop. After hearing the submissions of learned counsel for both the sides, I find that there is an order dated 29/6/2022 passed by the learned single judge in 4441/2022, whereby the appointments have been made subject to further orders. Which is the order by which it has been made subject to?
Order dated 19/9/2020.
Page number?
Lordship's file, it is there.
It is, oh, yes.
Lordship's file.
Right.
19/9.
2022.
Yeah.
In this proceeding, making the appointments, if any, made during the pendency of the writ petition as subject to further orders that may be passed in this proceeding. However, what can also be seen is that if the petitioners succeed in this writ petition, they could displace up to 7 appointed candidates belonging to the EWS category. First off, however, notwithstanding the same, none of the EWS category candidates are parties to this proceeding. First off, therefore, if an order in favor of the petitioner is eventually passed, this same may be in violation of the principles of natural justice insofar as the already appointed candidates are concerned. First off, Mr. Mohanto submits that the list of names and other particulars of the EWS category candidates in order of merit are not available with the petitioners, as a result of which his clients are not in a position to implicate them as parties. Full stop. Situated thus, Mr. P. Nayak, Lineage Standing Counsel, PNRD, Assam, has prayed for to seek instruction and furnish a list of appointed candidates belonging to the EWS category.
Only 7, I think.
No,
7
let
from-
all the EWS category candidates with their respective merit position to the petitioners, so as to enable them to implement.
Merit position is already there.
Hmm.
In the writ petition itself from page 65, merit positions are there.
Hmm.
EW candidates are also there. Minor senior advocate lordship who wants to make parties, who are the selected candidates lordship, if he gives their names, then I can provide the address lordship instead of all lordship. Against all the EWS, they have no grievance.
Who we want to make parties?
No, then in that case, my lord, this list.
Pays for 7 days time to
From
furnish
bottom.
the address and other particulars of those EWS candidates who the petitioners seek to implement in this writ petition.
If they have been appointed meanwhile.
Yeah,
because
that's
for
what, appointed candidates.
Yes, appointed, their appointment letters should be given to us so that we can put to check.
It is subsequent to, because it has been complied with.
First you implead them, then automatically when notice will go. In view of the above, the petitioner's counsel to furnish the list of candidates of the EWS category who have already been appointed and whom the petitioners seek to include in this petition within a week from today. Once such list is furnished, the learned standing council will obtain instruction and furnish their addresses to the petitioner's council. Thereafter, appropriate application for improvement be filed. List the case accordingly.
Yes.
There is no escape. You have to, otherwise you will not get any relief here.
Well, exactly, that would cleanse the issue, otherwise another controversy might arise.
That's
So
right.
that-
Or you can argue that they are not required to be made parties. Either
Yes.
of the two.
I'll see to it, Malad. But then apparently I hold the opinion for myself that in such a matter, probably they are not required. Otherwise, there will be no end of the matter. Tomorrow you go and appointing and have to go.
Then I'll recall this order, you argue, but if you are not able to satisfy the
Malad,
court, then
so-
really proceeded. That comment.
But it is not really fair approach, but it has complicated the issue by issuing.
The government has gone by the court order. How can it be answered?
No, whether that is why I wanted to see whether in their appointment letters they have mentioned the conditions the honorable court wanted to put it there. If that is there, they know about that the case is pending, they will be bound by the order, then in that case, they cannot allege prejudice. Then I am protected.
So then according to you, this order, their appointment can be set aside even without hearing them.
Yes, well, because option is left to them if they know that they are getting an appointment, but it is conditional in a particular case pending, they have the option to come and join this procedure. That is the
You
notification.
want to
to them.
argue on that point, then I'll recall this order. But
Then
if
this
you
can
don't
be done. That
succeed,
is why
then
I do not know
then the
whether they have
repatriation will
mentioned
go.
it or not. They have, I do not know the appointment letters, they are supposed to mention. If they had not mentioned, then of course they have a point to say that we didn't know because it was not mentioned in my appointment letter.
If they have not mentioned, then. we'll be
Then
very-
definitely they have a point. That is why I wanted to know if they have mentioned it, they may provide it with those appointment letters. And if it is not mentioned, notwithstanding whether they have committed contempt or not, but we will have to make them parties so that they get the information. That, look, this is how your appointment was covered by an order.
Do you have instruction on that, Mr. Nayak?
No, Lordship.
Can you find out?
Let them give us the next week.
The officer, just now I talked to her, Lordship. She is aware of the course.
No, what he's saying that has it been mentioned in the order of appointment that this will be subject to? It is definitely mentioned. It's a court order. It has been mentioned only in the EWS category candidate, not others. Yes, that's all right, let him get that.
Just interim order, support order. The first order, my lord, Honorable Justice P.K. Jakamal.
What is the date of the order?
My lord.
26.
26?
26.
2020. 26/4/2021. my lord.
So today, we are not going to hear it for admission today. That question doesn't arise. It is only for stay matter. Stay order has to be extended.
The stay has to be extended, and my lord, the matter was fixed for hearing. It was coming under the hearing column earlier, my lord. But I'm not aware why it has come under the stay. Because pleadings are complete, my lord. There are orders that the matter will be taken up for disposal, my lord. And
No,
my lord,
there could be order, but as a judge, I have to agree. Na?
my lord,
You can't force me to do
no,
it.
no, that's not my
I'm
intention.
not going to do it today.
That's not my intention. But there's certain, my lord, there's certain things, my lord, which my senior wants to address. My lord, just it won't take much time. Just 5 minutes, my lord. There are certain
Let him come, choose a date after 2 weeks for
My-
admission
I'll-
hearing.
I'll-
You tell him that this is the order I am going to pass.
My lord, he'll address your lordship for 2 minutes.
Yes, yes.
I'm very grateful, my lord. I'm deeply obliged.
For hearing.
The matter which relates to removal from service, which was then converted to compulsory retirement with pensionary benefits in revision, in the Department of Revision. Here, the petitioner, he was serving as a head constable driver in the Central Industrial Security Force.
Head constable driver.
Driver, he was appointed in the Central Industrial Security Force in the year 1997. In 1991. Then on 5/3/2010, he was transferred to CISF unit oil Duliajan. He was to report there on the 16th. 15th, he reached Duliajan. Admittedly, he took some alcohol. On 16th, my lord, when he reported for duties at the office, he was taken to the doctor directly. Smell of alcohol was found. A disciplinary proceeding was initiated and he was removed from service. Thereafter, he filed an appeal, my lord. That appeal, the removal order was not touched. In the revision, my lord, it was converted to compulsory retirement with pensionary benefits. Pension given to him at the point of calculated to him was around 2,900 rupees. We are challenging the original order of the disciplinary authority. And if that goes, my lord, the consequential orders will go.
What is the ground of challenge?
My lord, the inquiry was totally biased. Inquiry was biased inquiry, my lord, that I will show. And the manner in which my delinquency was required to be proved for the judgments of this honorable court, that was not done. There were two charges. One charge that I was intoxicated on that day. The second charges was that I already had 11 minor and 1 major, 10 minor and 1 major punishment in my past career. So this was in my earlier unit. In this unit, this was my first day. And that I cannot deny because those punishments are a matter of record. Now, if the first charge, if it goes, then my lord, perhaps the whole order passed with disciplinary authority would have to go or would require reconciliation. So my lord, here what happened is, during the inquiry proceedings, the inquiry officer was cross-examining the delinquent officer. He donned the role of judge and prosecutor, although there was a presenting officer in the inquiry proceedings. Presenting officer did nothing. Everything was done by the inquiry officer. Honorable High Court and the Supreme Court has said that once the inquiry officer starts cross-examining, whether the inquiry is biased, it has to go. Secondly, the manner in which the intoxication part was to be proved has been dealt with by this honorable court in several cases. I refer to the judgment that process was not followed at all. Lordships kindly have the memorandum of charge, madam. Page 23, madam, constitution.
Yes.
Starts at page 23. Page 24 is the gist of charges. That force number so and so.
The incident happened when he was posted as a CISF unit at
Duliajan. He was posted to Duliajan by on transfer. He was to report on the 16th. The 16th, the incident happened. 16th of March 2010.
And originally he was appointed as head constable driver in
In the CISF, but in another unit, he was in Nunmati, CISF Nunmati at that point of time when he was transferred. That transfer order, Lordship, I have given at page 21. From Nunmati, he was transferred to Duliajan by order dated 5/3/2010. Required to report on 16th of March 2010 on availing joining time. Page 24 is the article of charge, madam, that force number so and so.
Can we read it? Can we read it?
Madam?
Then please read it.
Madam, yes. Force number so and so, head constable driver Gautam Talukdar of headquarters sector CISF unit Duliajan had reported to CISF unit Duliajan on 16/3/2010 on transfer from CISF unit IOC Guwahati, but he was found under influence of alcohol at about 1100 hours on 16/10/2003 while reporting to his superior. Being a responsible member of the force, his act amounts to great misconduct, indiscipline, and negligence. Hence the charge 2. Post number so and so, driver Gautam Talukar of headquarters sector CISF unit or Duliajan is charged with incorrigible behavior of misconduct and indiscipline that in that he has earned bad service record by being punished with 1 major and 10 minor punishments during his career, which is highly objectionable. Hence the charge. Thereafter, my lord, the imputation of charge at page 25. The earlier punishments given at page 26. My reply to this charge sheet, my lord, is at page 36. And although the date has not been recorded in the 36, my lord, from the records I have found that it was dated 24/5/2010 at page 36. This was my reply, my lord. With reference to your letter cited above, I beg to submit following lines for your kind consideration. That on 5/3/2010, I arrived at Duliajan from IOC Guwahati to join at the post of head constable driver at Duliajan. On the same day, that is 15/3/2010, I met one of my close friends with whom I enjoyed the night with a small party by taking some alcohol or liquor. That on 16/3/2010, I joined the office at CISF unit in Duliajan. At about 11 a.m. on that day, I had not taken drink a single drop of alcohol, as the smell which arises from my mouth was of the previous day. That, sir, alleged act on my part was not intentional but accidental, for which I beg to be excused and request your good self to waive my charge and being my maiden offense. That I hereby bind myself and assure that I shall never repeat such act in future, that I am the sole earning member to maintain my family and my ailing father, that if you impose any penalty, my family member will suffer a lot and face financial difficulties unless I am forgiven for my act, as the same is a petty offense. Therefore, I request you to kindly excuse my civil offense. So, not being well satisfied with this reply, the inquiry officer was.
What is this alleged act?
That alleged act of that consumption of liquor on 16/3/2010 when we reported for duties.
No, but he said he was under some influence of alcohol.
When he said, my lord, that he taken some alcohol on 15/3/2010 and the smell was coming from that. I will read again, my lord. Para 2. That on 16/3/2010, I joined the office at CISF unit on Duliajan at about 11 a.m. On that day, I have not drink a single drop of alcohol, as the smell which arises from my mouth was of the previous day. He said that I had taken some alcohol on the first paragraph. He said, on 15/3/2010, I arrived at Duliajan from IOC Guwahati to join at the post of head constable driver at Duliajan. On the same day, on 15/3/2010, I met one of my close friends with whom I enjoyed the night with a small party by taking some alcohol or liquor. 15/3, he reached Duliajan. 16/3, he was what to report. They found the smell of alcohol. Not being satisfied with this reply, my lord, at page 37,
Yes.
the inquiry officer was appointed on 31/5/2010. Then at page 39, my lord, the presenting officer is appointed on the same day. And after the inquiry, my lord, the inquiry report was submitted. On 14/8/2010, that inquiry report, lordship will find at page 41. Lordship would permit me to go through some portions of the evidence which has been recorded, because I will have to support it with my judgments. On page 41 is the inquiry report, where he gives the preamble, the charges, and thereafter lordship would find at page 42, he gives a list of the documents which has been exhibited and the statements of the witnesses which were recorded during the inquiry. That list is given. At page 43 are the statements, my lord. Now, this is the statement of the first witness, Inspector Executive Gorakh Singh, who was the company commander, who was required to be my company commander. He has simply stated that I am required to produce the medical examination certificate of the delinquent officer, and I have done. When I asked if lordship comes to questions put by the accused head constable driver down below, question number 1, Did you see me whether I had taken alcohol or not? Answer is no. Then how did you adduce evidence on the basis of records available in the office? So his statement in the earlier paragraph that I must have consumed alcohol was on the basis of some record. Number 2 would be important, my lord. I, force number so and so, served in this unit from so and so, and at present I am posted at IJ Airport, New Delhi. On 16/3, I was informed by the control room of the orders of the Assistant Commandant Headquarters Sector requiring me to get head constable driver who was standing near the main office medically examined at the oil hospital. Then I proceeded to the oil hospital with driver Contempt along with head constable GD Balaji Raju, constable so and so and constable so and so, in respect of which I am exhibiting entry at serial number so and so. When I took head constable Gautam Talukdar, he appeared normal, but his mouth was smelling of alcohol. The medical officer, after examining the said head constable Gautam Talukdar, had drunk, said that head constable Talukdar had drunk alcohol. After medical, I came back to the unit headquarters with head constable Gautam Talukdar. The presenting officer denied to put any questions. Questions put to the PW2 by the accused. How did you know that the smell of alcohol was coming from my mouth? When I was talking to Gautam Talukdar, some smell like alcohol was coming from his mouth. Now the third witness, my lord. I am PKD, I am serving in this unit so and so. At present, executing duties of BHM, head constable Gautam Talukdar reported to this oil division from so and so at 9:40 hours, and he came to me after reporting, and I told him to come out in good turnout for interview with the commandant. Gautam Talukdar came in proper dress, and while taking him near commandant office, I got the smell of something like alcohol coming from his mouth, and before taking him to the commandant, I took him to the assistant commandant. My lord, here I will show how it contradicts with the statement given by the assistant commandant. He gave a very contradictory statement. Before taking him to commandant, I took him to the assistant commandant, and assistant commandant said that his mouth is smelling of alcohol and directed him to take to IL hospital. Then lordship, the questions put by the presenting officer at question number 2. How did you find the condition of head constable driver while taking him to interview? Everything was normal, only his mouth was smelling. Question number 2. In the middle, lordship finds question number 2 at page 45. How did you find the condition of head constable driver while taking him to interview? Answer. Everything was normal, only his mouth was smelling. Then, my lord, my questions put by accused Gautam Talukdar. Question number 1. What was the smell? I do not know what his mouth was smelling of. Thereafter, lordship will find on the next page, page 46. This is the statement of a ministerial who had accompanied me, who had taken my biodata when I had entered the office. The questions put to PW4 by the presenting officer during the inquiry, that's what lordship will have. Question number 2 again. When you were filling up the form of said head constable driver Gautam Talukdar, was he drunk and was his mouth smelling? When I was filling the biodata form of the aforesaid person, he was chewing something and his mouth was smelling of betel nut. I did not feel that he had consumed alcohol. This is a reply to the answer put by the presenting officer. Thereafter, lordship would find at page 48. Page 48. Serial number 6, statement of the assistant commandant who had sent me for the medical examination. The fourth line from the top on the middle, it's on 16/10, lordship finds. On 16/10/2010, while I was discharging my duties in my office located in the office unit at about 1100 hours, Head Constable PK Day came to my office and said that, sir, I was about to present AC driver Gautam Talukdar, who has come on regular transfer from IOC Guwahati before the commandant, but he has consumed excessive alcohol and is in a state of intoxication. And when I informed the same, the commandant has directed to produce him before the assistant commandant. Now, when I had earlier said that this was one of the evidence was contradicted by the assistant commandant, lordship is page 45, where PK Day who brought me said, because I got the smell, I took him directly to assistant commandant. Now, assistant commandant says he was sent to the commandant and brought back to assistant commandant. So, my lord, this story as to how I was taken to the assistant commandant, I was sent to the hospital, my lord. The two key witnesses, my lord, they did not corroborate each other. Thereafter, Lordship will find at the next page, page 49, the answer to question number 1. At page 49, my lord. I came before this question was put by me. I came before you at 1100 hours. No one assisted me, nor did I misbehave with you. Then how did you know that I was drunk? I have not stated that you were unable to walk or that you misbehaved with me, but it appeared from your actions and some smell like alcohol was coming from your mouth. And when I asked of you that this is your first day in the unit and when you had been called for by the commandant for interview, then why did you drink? You said that you had made a mistake of meeting the account. So it was again because some smell was coming from my mouth. Thereafter, Lordship would like to have at the same page, page 49, last question, the statement, the last line, questions put by presenting officer to PW7. At page 50, in answer to question number 3, he says he seemed normal and it was smelling and he was chewing pan. So all the witnesses, I will not go through all the witnesses, but all the witnesses said only one thing, that my mouth was smelling and I was behaving normally. Thereafter, Lordship will find at page 52. This is PW9, my lord. Little bit important, my lord. Page 52, question number 7. This was to a reply to the inquiry officer. Question number 7. Did you feel from the action of H driver Contempt Talukdar from observing him that he had consumed alcohol? No, I did not. Then question number 10. Then do you want to say that Head Constable Contempt Talukdar had not consumed alcohol? I did not feel that he had consumed alcohol. These were persons who had accompanied me in the gypsy to the hospital. Now, Lordship will kindly come to page 53, where my statement was recorded, and here the biasness of the inquiry officer is apparent. At page 53, Lordship will find it is statement of force number so-and-so, Gautam Talukdar, headquarters sector, CISF, oil, unit oil, Buliajan. This is my statement. I will not go through the whole story because I have repeated the same story. At the bottom, Lordship will find examination by inquiry officer of Head Constable driver Gautam Talukdar. He goes here to examine me. And on the next page, at page 54, in the middle, Lordship will find that he cross-examines me thereafter. He first examines me, and then at page 54, he cross-examines me. Cross-examination by the inquiry officer of accused Gautam Talukdar. The moment, my lord, the inquiry officer, I stand in my defense, the moment the inquiry officer starts to examine me and cross-examine me in the presence of the presenting officer, cross-examination part, my lord, in my humble submission, the entire inquiry proceeding has to go, the biasness becomes apparent. This is, my lord, the first limb of argument. And Lordship would like to have at page 55, from the very beginning, I had taken the stand that the doctor who had supposedly examined me was not brought onto the witness box, and therefore, my lord, I could never cross-examine him. The question number 3, as per evidence of PW2 on medical examination by the doctor, you have found to have ingested alcohol, which is supported by the certificate of the doctor and by evidence when you have stated that after examination, doctor said you were drunk. What do you have to say on this? Is this not a leading question, my lord, put in by the inquiry officer to me? The doctor tested me by machine, but neither blood test nor urine test was conducted. I do not agree to the result of the machine. Therefore, it is false that I had taken any drinks. Thereafter, my lord, he goes on to discuss the brief note of the presenting officer and my defense brief. And Lordship would find at page 65, he gives his conclusion. At page 67, that the charge is fully proved. An article of charge 2, where there were a number of punishments against me, that is also proved. The order, just for Lordship's satisfaction, my lord, at page 79 is the original of the presenting officer's report. At page 79, Lordship could find in the middle where the question answers are given. Just before that, जांच अधिकारी द्वारा बचाव पक्ष के गौतम तालुकदार द्वारा दिए गए बयान के बाद परीक्षण, this is examination in the middle, and at page 80 Lordship will find the first line, जांच अधिकारी द्वारा किया गया प्रति परीक्षण. In fact, this is admitted by the disciplinary authority in his order, saying that the inquiry officer has cross-examined the accused. So technically, my lord, on that very ground, my lord, I can pray for the setting aside of the inquiry report, which will, my lord, lead to setting aside of the disciplinary authority's order. And all consequential orders passed thereon. These grounds have been taken in the appeal preferred before the Department of Authorities. The final order, my lord, will find the order passed by the disciplinary authority at page 93.
Yes.
Page 93, my lord, the order of the disciplinary authority, where he records, while conducting the inquiry according to rules, the inquiry officer recorded the statement and also cross-examined accused constable Gautam Talukdar. Page 94, my lord, somewhere to the middle. The sentence starts with evidence.
1 minute, 1 minute. Why did you say cross-examined which part?
My lord, page 48. I'm sorry.
No, page 93 you just read.
Page 93. Yes, ma'am. Page 93, the order starts. At page 94 is the cross-examination. Page 94.
Which part?
Somewhere in the middle, my lord, where the sentence starts with according to rules. That line starts with according to rules in the middle, my lord. The date is given 27, 5 lines thereafter, according to rules. Around 17 line from the top. While conducting the inquiry according to
You are
rules.
saying it is on page 94.
94, my lord. 17th line from the top.
17th line from the
Top. Seventeenth line from the top. The last word in that line is inquiry. In that line is inquiry, my lord. While conducting the inquiry according to rules, the inquiry officer recorded the statement and also cross-examined accused Gautam Talukdar on 26/7/2010.
Yes.
Now, my lord, at page 101, he finally comes to the conclusion that I have committed both the misconducts, and at paragraph number 9, the punishment of removal from service with immediate effect is inflicted upon me. This is an order of 14 September 2010. Now at page 104, my lord, in the Hindi version, it is written clearly that uska pratiparikshan kiya. Inquiry officer ne uska pratiparikshan kiya. So there is no difficulty in translation of it. And lordship kindly has my appeal file at page 111. Serial number 3, my lord. My ground number 3. The final order is based on the erroneous finding of the disciplinary authority. The disciplinary authority failed to examine the doctor of the Oil India Hospital who examined the appellant. The doctor is the main witness in the above proceedings.
So where is the judgment you are referring to? Inquiry officer cross-examination.
My lord, that is Ram Lakhan Sharma. Union of India versus Ram Lakhan Sharma, my lord.
Yes, who is appearing? What is this charge number 2 is? What kind of a charge is this? He was found guilty in earlier occasions, so this is a charge. Whatever has happened in earlier occasion has happened. What has that got to do here? And where is the proof that he was drunk?
My lord, that
Smelling is one thing and drunk is another thing. Where is the proof?
I'll place my lord before the court.
Which paragraph in this judgment?
Page 8, paragraph 26.
Hmm.
And my lord, at paragraph, page 9, the second last paragraph over para 29.
Sorry, which
Page-
para you are referring to?
My lord, page 9, last part of para 28, just above para 29. As far as position in law is concerned, it is common ground that if the inquiry authority plays the role of a prosecutor and cross-examines defense witness or put leading question to the prosecution witnesses, clearly exposing a biased state of mind, the inquiry would be opposed to the principles of natural justice. But the question for consideration in this case, in that particular case, whether the inquiry officer did so, in our case, it was done. He is entitled to push questions. So the part where he was examining me, I'm not against that. The moment he starts cross-examining me on what I have said, he my lord becomes biased. He wants to prove me wrong. That he cannot do. Then at para 32, madam. Para 32, page 11. The division bench, after elaborately considering the issues, summarize the principles in paragraph 15, which is the following effect. 16, subclause 2, madam. Subclause 3. The inquiry officer, with a view to arrive at the truth or to open clarifications, can put questions to the prosecution witness as also the defense witness. In the absence of a presenting officer, if the inquiry officer puts any questions to the prosecution witness to elicit the facts, he should thereafter permit the delinquent employee to cross-examine such witnesses.
Achha, have you got any decision on proportionality of penalty?
Yes, madam.
You have got it?
Yes.
Show me the judgment. Ms. Gayan, there are three things here. There is no need to spend a lot of time in this matter. First, there are two charges. One is that he was in intoxication. There is no proof of that. Somebody has said that they smelt something like alcohol. Even if that is correct, that is no charge. Unless someone is found to be in an inebriated state, and that is established by medical evidence, not proof. The second charge, that he was found guilty earlier and penalty imposed, that is not a charge at all. How can that be a charge? Then you will go on punishing people. Once he is punished, penalty is imposed. So again, he will draw up proceedings saying that since you are earlier punished, so this is a misconduct. How can that be? So we'll set aside this order unless you have something to say and direct that he should be reinstated.
I'll place some point regarding the intoxication, to prove my case,
No, but unless medical evidence is there. we will not
That
accept.
is page 42,
Page 42.
42, yes, ma'am.
What is there in page 42?
The following documents were produced during the inquiry. That document number 5, my lord. Report of the medical officer of all hospital division with regard to the HC driver Gautam Talukdar. Exhibit P3 EW1, my lord. And
TW1 is the medical officer.
No, my lord, that is
The person who
exhibit,
produced.
that was the exhibit before that, and before the proceeding, my lord.
That's correct, but
Yes,
that
ma'am.
document has to be proved by someone. Who has
And-
proved it?
And my lord, kindly see the statement of the petitioner in page 54, my lord.
No, we'll go to 54. First, tell us this. Exhibit 5.
Yes, my lord.
It's a medical report.
Yes, medical.
Who
report.
has proved this?
My lord, that is the medical report, my lord, that is.
Who has
super-
proved this document?
My lord, he himself admitted in question number 4 of my lord, in page number 54, my lord, kindly see, page number 54, my lord.
Hmm. So nobody has proved this document.
Page number 54, question number 4, my lord. May I read, my lord? Question number 2, do you admit that doctor, doctor?
Doctor said that you were drunk when the red bulb flashed. After the red bulb-
After red bulb flash, the doctor herself said that I was drunk. Then next question, my lord, do you want to say anything further? No. Then next question, do you want to present anything and other evidence on this? He said no, my lord. That means that he himself admitted, my lord, he was drunk.
What is the red bulb? What machine is this called?
That is a blowing
Breath
machine.
Huh?
That
Breath
blowing.
analyzer.
Breath analyzer.
Yes, my lord. That he himself admitted, my lord. That was red bulb was flashed, my lord, when he glowed, my lord. That was his admission part of my lord. Before that
Admission was not on-
proceeding,
No,
my lord.
his admission was that doctor said this.
Yes.
His
Yes, ma'am.
admission is not that I was drunk.
Not, but he said that, do you want to say anything further? He did not say that this is the result of that earlier, my lord, last night, the incident, my lord. And do you want to present any other evidence? And he said,
No,
no, my
you
lord.
see, nobody is saying that he's a teetotaler or he never took drinks. That's nobody is saying that.
Yes, ma'am.
But he has an explanation that he overdrank the previous evening. Correct.
Yes, ma'am.
So it is possible that when he came to duty, he might have been smelling of alcohol. That we are not doubting.
Yes, ma'am.
But the question is, was he in an inebriated state? And therefore, will it constitute a misconduct? Even if it constitutes a misconduct, would it be such a grave misconduct to invite a major penalty of removal from service or compulsory retirement? That is the only thing we will consider here. That's why we are asking proportionality. Are you both prepared to argue on that? I will close the matter then, if you are ready to argue on proportionality. Because even assuming that he was smelling of alcohol, let's accept that that is correct. Because you don't have any evidence to show what was the level of intoxication, that you don't know. Some witnesses have said there was nothing abnormal. Some witnesses have said he was smelling. Some report says there was a flashing of red bulb. But all these things put together does not say that he was drunk. It can only say that he was having signs of intoxication, and the timing was in the morning. It was 11 a.m. So therefore, it is possible that late night consumption of alcohol could have a spillover effect. That is possible. But there is nothing to show that he consumed alcohol before coming to duty, or that his alcohol level in his blood and urine were so high that it could not have happened unless he had consumed. So if somebody consumes alcohol and then comes to the duty, it's a serious matter. We do agree, because that would be an act of irresponsibility. But that cannot be equated with someone smelling alcohol because he had consumed something in the previous night. Where has this argument been dealt with by the inquiry officer? His stand that he had consumed a lot of alcohol the previous night. What is the answer given to that? Show us that.
Page 63, para 11.
Yes. What does it say?
Accused SC driver Gautam Talukdar of headquarters so-and-so stated in his statement that on 15/3 about so-and-so, he reached his unit from IOC Guwahati and told the BHM that he's joining his own phone on so-and-so, and then BHM told him to come next day at 10:30 and was for interview. He reported at the control room at so-and-so and met the BHM in the main office, and then the BHM told him to go to the office to get his biodata endorsed, and therefore you'll go for the interview. After it got his biodata endorsed, he was taken by the BHM to the assistant commandant for interview, and even as he entered the chamber of the assistant commandant, he said it is not was smelling. He came after consuming alcohol. Then he replied that I had consumed little alcohol on 15/3/2010 before going to sleep due to exhaustion. I have not drunk a single drop. 16/3/2010. This is true. On this, the assistant commandant said that take him for medical examination to the oil hospital to get him medically examined. As per his orders, he was taken to the oil hospital and lady doctor was present in the doctor's chamber. The doctor asked him to walk and talk. He walked and talked. After that, the doctor kept a machine in front of his mouth and asked him to blow into the machine, and he blew into the machine. After he blew, the red bulb in the machine flashed. Upon this, the doctor said that he had consumed alcohol and then came out of the chamber. Further, he has stated that he was examined only by machine, and machines do not always give the right result. Many a times it gives wrong result, and it is a fact that on that day it gave a wrong result because my blood and urine should have been tested so that concrete evidence could be collected. But his blood and urine were not tested only since a red light in the red bulb in the machine flashed, I was declared to be inebriated, and he had not consumed alcohol on 16/10/2003. No one had assisted him, and he had gone there himself, and everybody had also stated that he was normal. If he is not intoxicated, then he could not have done anything normally. If he was totally normal, he had not taken anything. During the department inquiry, after due consideration of prosecution witness evidence of documents, the following facts have come to light. He does not discuss why this is wrong. He simply comes at now the following come to light. Then he goes on to discuss the prosecution witnesses. He does not discuss next time.
Difficult, Ms. Gayan. Go through it once again.
Yes, ma'am.
We'll take it up on when? Thursday. What had matter?
Yes.
Heard Mr. R. Mazumdar, learned counsel appearing for the petition. And give me the judgment and professional.
My lord, I have given my lord, that contains both how consumption of alcohol is to be proved, and even if proved, what would be the then it is disproportionate.
Which paragraph?
My lordship would like to have page 7. Page 7, my lord, the consumption of liquor, there is no paragraph number on that. And otherwise, then page 9.
Well, this is exactly what I have just pointed out.
Yes, my lord. It goes exactly for that. And at the last page, paragraph 14, page 13, last paragraph, paragraph 18.
Yes, smelling of alcohol is one thing,
Yes.
and coming in duty in an inebriated state is another thing. And then the inquiry officer has also recorded findings that this is what his stand is. You see, dismissing someone from service is, you are not only punishing him, but also his family.
Whatever I can place on 9th manner.
And also tell us
Yes.
if the order goes, then how soon you can reinstate him. Ms. A. Gahan, I will see, praise for time till 9/2/2023 to make her reply arguments. They are allowed. List this case again on 9/2/2023 as fixed parted matter.
Item 13 to 17.
Please, Your Lordship. Your Lordship, item number 13, 14, 16, and 17 are filed by our client, the petitioners. And item number 615 is my learned senior represents those clients as petitioners, Your Lordship, in the matter. Here, Your Lordship, the matter pertains to the inter se seniority initially in the grade of rangers in the forest department. If your lordship can kindly take up the last item, your lordship, only one petition would.
So it is for final hearing today.
Yes, sir.
How much time will you take?
I'll take not more than 45 minutes, your lordship. That is all, or not. 45.
Yours?
I'll take about 15-20 minutes.
Then we'll take it up at 2 then.
There's one NRC matter, item number 22.
Yes. Just come for stay matters.
No, my lord, actually, there is an order, pursuant to that, the government should produce the instruction. So that lordship can, if your lordship would kindly have a look at order dated 28/4/22. Please come to the first subpara. Petitioners are aggrieved by order dated 26/3/21, whereby services of the petitioners were terminated with effect from 30/4/21. Petitioners were appointed as junior assistant under the NRC after following due selection process. The updation of NRC in Assam started with the direction of the apex court and continued such updation under the supervision and monitoring of the apex court in connection with WPC number so and so. Petitioners were terminated on the ground that the services are no more required. Petitioners assert that NRC updation is a continuous process under Rule 11 of the rules. Sri so-and-so learned counsel, relying upon the communication dated 21/8/19, submits that the state coordinator Assam proposed before the Registrar General of India for continuous updation of NRC under Rule 11. Pursuant to such communication, while Annexure 1, the additional Registrar General requested state coordinator to send the detailed proposals to the state government along with the timeline and financial implication. Pursuant to this, state coordinator NRC Assam, by communication dated 8/11/2009, forwarded the proposal regarding continuous updation of NRC to the state of Assam in Home and Political Department. Sri so-and-so learned counsel further highlights that in the said proposal, post of 409 junior assistants which the petitioners were holding were shown to be required for continuous updation of the NRC process. Subsequently, in NRC Coordination Committee meeting held on 2nd of July, agenda number 6, necessity of same proposal was reiterated. Therefore, Sri so-and-so learned counsel submits that ground of termination of the petitioners are perverse and same are sought to be done to accommodate some other person. In that view of the matter, RKD Chaudhary, learned standing counsel of NRC, shall obtain instruction regarding status of such proposal, and AK Datta, learned CGSC, shall also obtain instruction whether state of Assam has sent the same proposal to the Registrar General, and whether, if sent, what is the status of such a proposal. So, my lord, the groundwork was done. All of a sudden, they have taken the recourse of termination. So this
Your clients are in service now,
no,
but
There
there
is
is
an
some
interim
order of status quo.
yes. In spite of that, neither they are paying the salary, nor are they permitting us to, my lord, discharge any job. Now,
Right.
these are the ground realities, my lord. Now, where is the scope of termination?
All right, so today what,
So what I am saying is, my lord, pursuant to this order, they should get the instruction. Why they are not here? April 22, my lord.
Perhaps my senior friend has missed out, worship. In fact, the instructions had been placed to the honorable, so I have got a copy of this. It's on 6th May 22.
6 May 22.
Nine.
Last order is supposed.
yes, it is there, it is there.
They are supposed to file an affidavit.
That can be brought on affidavit, that's not what the instructions have been placed. worship.
What does it say? 6 May, have you got the copy of?
No, my
6 May?
No, my lord. No, as per the last order, 2010-2022, they were supposed to file an affidavit. The
Worship,
instructions were not furnished.
I fairly admit that has gone out of my mind. I can bring it on.
Let him file the affidavit.
It's not an issue.
Mr. Kane Chaudhary, senior counsel.
Only the matter is being, continuing. Council will fix a
Let
date
it be
in the
the-
month of March, my lord. In the meantime, let them keep it for final. At least we should know where you stand, my lord.
Worship,
Except
let
the
it be
day,
in the month of February itself. Worship. I also want to get it over.
in the later part of February.
No, we'll fix it in February. Once the pleadings are complete, then
Flush,
fix a
flush.
date.
My lord.
I heard Mr. Kane Chaudhary and senior counsel respected by Mr. P. Montal and counsel appearing to the petitioner. Who submits that despite the order dated 28/4/2022 passed by this court, the respondents have not yet filed affidavit placing the instructions on record. Full stop. Responding to the above, Mr. RKD Chaudhary, learned DSGS submits that the written instructions have been received on 6/5/2022 from the Secretary to the Government of Assam, Home and Political Department and State Coordinator NRC. And therefore he be granted time till 27/2/2023 to place the same on record in the form of an affidavit. Taking note of the request made by the learned counsel for the respondent, this matter is directed to be listed again on 27/2/2023. Subject to completion of pleadings, a date of final hearing and disposal of the petition shall be fixed on 27/2/2023 with the consent of all the parties. Interim order passed earlier to continue. Yes.
He tried to arrange to attend your lordship's court, but there is a matter of 1994 in court number 8, lordship, regarding habeas corpus matter. So he has to attend that matter, lordship. So I'm praying, but my lordship, and he has some urgency, lordship. The same.
So what is to be done?
Lordship, I am praying for an adjournment for today, your lordship, accommodation for today.
My senior has issues and can have no objections to it. Your lordship will kindly fix a date. It's 10 years have passed by some or the other, your lordship.
What is the matter about?
The matter, your lordship, is there was in 1989. In 1989, the APSC issued an advertisement for the post of 18 number of stipendiary rangers. The selection process was carried out. In 18, there was a select list which was published of 18 individuals. My petitioners were there as a part of the select list of the 18 members, your lordship. Thereafter, by a separate process not sanctioned by the APSC, 17 other candidates joined the same course and they happened to pass out at the same time. In 2005, there was an OM which stated that the seniority in that batch will be as per the APSC merit list.
Yes.
There's a dispute between two batches, my lord. One has undergone a specific training, my lord. One has come through, my lord, APSC merit list.
So, my lord, and my lord, this matter will require consideration in the presence of Mr. Chaudhary, Mr. K. Senior Counsel. Actually, my lord, stakes of many other petitioners also, respondents are there, my lord. So he's representing those, my lord, and well, let him complete, my lord. We'll counter, my lord. Other than that, my lord, it's a squarely covered case by one citation, my lord. In fact, with just one matter, 13 was the first matter. During its pendency, there was another round of litigation which was contemplated. In fact, your lordship had heard the matter once while a review petition had been preferred before this court. All the subsequent petitions are additions of subsequent facts. So your lordship can kindly, if lordship takes up.
Then we'll take it up on 14th February.
Yes, yes.
Top of the list.
Yes, your lordship. Yes.
Lordship, in that case, lordship, if it is before or after, lordship, because my senior had some constitutional matters and Supreme Court, lordship.
We can't help it.
Maybe before 10th, lordship.
We can't help it. Then we can take it on 16th.
Yes. Any date your lordship fixes.
On the request of learned counsel for both the sides, including the learned departmental counsel appearing for the forest department, Assam. This batch of writ petitions are directed to be posted for final hearing again on 16/2/2023 as fixed items. First up, it is made clear that in view of the urgency expressed by the petitioners counsel in item number
13, your lordship.
13. No prayer for adjournment will be entertained on the next date fixed.
I'm grateful, your lordship. Let it be the top of the list, man.
List these cases in the top of the hearing list, in the top of the list in the hearing column on the next date fixed.
All right.
Yes.
Item 18.
With due respect, I submit, my lord, the facts of the case in brief, my lord. My lord, there was a recruitment process for store supervisor took place in 2013, my lord. There was a one post and the petitioner is the only departmental candidate. Why the petitioner applied, my lord? Because there's a stagnation in promotion of 20 years. He is drawing the grade pay of 19. The store supervisor grade pay is 2,400, my lord. So when this recruitment process took place, finalized, number one candidate, my lord, that is Kishore Akhtar, he finally did not pass, he medically failed. Or
There are two writ petitions.
no,
They
no,
are
no, no,
connected.
my lord, 19 is separate, small, I'll take small time also in both the petitions.
Hmm. Yes.
My lord, this 2214, he was declared unsuccessful, my lord. So the petitioner is number two, ST candidate, departmental candidate, is the only departmental candidate. My lord, the petitioner staked his claim for his appointment. But firstly, the department say, no, the vacancy has been converted to the DPC vacancy. So my lord, here my submission, humble submission is that without amendment of the RNP rule, can a vacancy open for the open candidate be converted to the DPC vacancy? One, my lord. My lord, I kept on writing, representing. In 2017 only, my lord, to my utter surprise, they stated, yes, after this Kishore Akhtar has medically failed. Before that, they kept it in confidence, my lord. My lord, then what happened, my lord? Then when I again prayed for it, they stated, yes, the vacancy is kept for 1 year only, my lord. But my lord, I again inquired for the same advertisement for the other post of Hindi translator. They were appointed in 2017, which I have placed on record in my pleadings, in my rejoinder, my lord. My lord, the two arguments they have brought forward in denying my candidature, which was due from 22nd February 2014, because I am before my lord not for any pay and allowances. I need only my antedate seniority of store supervisor only, my lord. So the two grounds they have brought forward. One ground is that, yes, the candidate, as my lord is well aware that the candidate, these vacancies kept for 1 year because so that the others should get a chance. They violated their own condition and law laid down by the Supreme Court, appointing Hindi translator in 2017. Second point, second ground they have brought in the counter affidavit, my lord. They say, no, it has been taken a decision that the post is not to be filled up. There may not be much work in the organization. They in 2017, they say. My lord, in 2011, in page 11, I have highlighted one Supreme Court judgment, my lord. It's very interesting, my lord. I read for my lord convenience, my lord. The judgments I have quoted, my lord. That's page number. It's my lord, para 10, page 9. So the C. Chitto Trinamool Director, C. Chitto Trinamool Institute of Medical and Technology, and another versus M. Pushkaran, dated 2008, my lord. The Honorable Supreme Court stated, I read, my lord. The application of law would therefore depend upon the fact situation, obtaining each case. The judgment of the High Court, in view of the above-mentioned authoritative pronouncement, cannot be said to be perverse. The respondent was to be offered with the appointment at a point of time. No policy decision was taken there were thus no reason not to offer any appointment in his favor. Even the purported policy decision was not in their contemplation. We therefore do not see any reason to interfere with the impugned judgment. So the two grounds, first ground is the validity for 1 year that is nullified by themselves appointing Hindi translator in 2017 of the same advertisement. In my case, they found exception. And my second ground, they say the work of the border roads organization has come down. My lord, there is in 2005, border road asked for 5,000 more employees because their border roads is working in ICBR road, Indo-China border road. There is a more manpower required. So as per the policy decision is concerned, my lord, they have incorporated this same thing, my lord. I read for my lord's
So
convenience.
you are presently working as what?
I am presently working as storekeeper technical with gateway 1900. So
Right.
I applied for the store supervisor
Right,
with
so-
gateway 2400
What
because
is-
there is a stagnation, my lord. So and I was in number 2 in the waiting list, my lord. So I was supposed to be appointed at 22nd February 2014. So they did not appoint me. So I am not no work, no pay. I am not asking for any pay and allowance, my lord. Because there is a stagnation. Advancement of the career is good for the employer and employee. I simply pray before my Lord, my seniority to be given from 22 to February when the cause of action arose, meaning thereby when the number 1 candidate was rejected finally.
The seniority over whom?
I should be given seniority of store supervisor from 2214. 2214.
But you say you are a storekeeper, not a store supervisor.
Yes, but I should have been, I have applied for the post of store supervisor, my lord. And that post, because past candidate failed vacant on 20.
No, you want that you will remain a storekeeper,
No, my lord.
then
I should be given the appointment of store supervisor with effect from 22nd. That is my prayer, my lord. 22nd February 2014. And interim stay has been granted also, and one post has been kept vacant since beginning when I came to before this honorable court in 2019, my lord. 16, page 11 is my prayer.
this post of store supervisor is a promotional post.
My lord,
Huh?
my lord,
The
And,
one post is lying vacant.
my lord. My lord,
Then consider his case and
no, prior to the completion of the the process, my lord, it was informed by the higher authority that not to give promotion without the approval of the higher authority. That is, and in the advertisement itself, page 17, page 17 of the requisition, there is a clause 1P. Page 17 of the requisition, small p, before to vacancies are liable to be increased or decreased without further notice. That was there. And page 24 of the same
no,
advertisement.
Mr. Please answer the question of the court.
My lord.
This post of store supervisor is a promotional post or a direct recruitment?
My lord, this advertisement was direct recruitment.
Direct recruitment.
My lord.
So today, what is the position? It's advertisement. This advertisement was not given effect to.
Yes, my lord.
Now, today, how do you fill up the post of store supervisor?
They have kept one vacancy.
You have to sit for the time being, yes.
One post keep vacant because of at that time.
Who is the officer here? Call him. I'm not getting answers from you. Tell him to come personally on Tuesday. I want answers. You are not answering the questions I'm asking. I ask you something, you go somewhere else.
No, my lord.
I'm asking you, how do you fill up the post of store supervisor today and where is the rules?
Well, that is still keep vacant. And this as the list was for
Then
1 year only,
direct personal appearance of who is the person here? You don't know. You don't have the answer to this, is it? Why don't you say you don't know? How do you fill up the post of supervisor, store supervisor? I'm asking you. Is it a very difficult question to understand?
No, no, my lord.
Then what is, how do you fill up? When I ask you, you go to the advertisement. I am asking you, what is the principle to fill up this post?
Regarding that, my lord, I am not so prepared. My lord. Today, my lord, some difficulties there. My lord, regarding that. My lord.
The moment the court takes up a matter for hearing, then you have a
No, my lord.
difficulty. You are hoping that it will be adjourned.
No, my lord. Further, my lord, I have some difficulty. My lord. I have taken some medicine also, and I am coming to the court, my lord.
We'll fix it on 9th. Are you available on 9th?
My lord, I am not available.
Then when are you available? We'll fix it.
My lord, is it possible for my lord to fix on 28th of March?
28th of March.
Yes, my lord. Because my wife had both the knee replaced.
All right,
So-
all right. Heard
And
Mr.
can it
T.
be
Das,
taken as a part-time matter?
Tapas Das, Leonard, the availability of this bench is doubtful. Then your matter will be further delayed.
Deeply upheld.
Tapas Das, Leonard Counsel appearing for the petitioner who submits that despite being eligible and having taken part in the recruitment process, his client was neither appointed as the store supervisor, which is a reserved post for ST category candidates under the Border Roads Organization, nor has the post been filled up by way of promotion. Full stop. According to Mr. Das, the candidate who was provisionally selected on 22/2/2014 for appointment as a store supervisor in pursuance to the advertisement notice dated. What is the date of the advertisement?
Date of the advertisement, yes, my lord. This is the employment date 8 to 14 June 2013, my lord. I have a copy of the employment news.
8 to 14.
8 to 14 June. Employment news.
8 February 2014.
8 June, my lord.
My lord,
8
published
June
2013.
2013.
2013.
Employment news. My lord,
Very difficult to pass an order.
I've got a
You
copy of
can't even say what is there in your hand. What is the date of the notification?
employment news dated 18 to, it is for 1 week period only. Employment news is published, my lord. So it is given 18 to 40.
Advertisement published in the employment news dated 8 to
8
14th of June
2013.
2013. And therefore, it is incumbent upon the respondents now to fill up the vacant post of store supervisor by promoting the petitioner, giving effect to such promotion with effect from the date on which the provisionally selected candidate was due for appointment. That relief we will not get it. It's not tenable, but we can see what is the rules and if we can ask for consideration of the case. Beyond that, you have to try somewhere else because I'll not pass an order which is not in accordance with law. But that kind of orders, you may get it. I don't know. Taking note of such grievance of the petitioner, a pointed query was made to Mr. K.K. Parasar as to what is the criteria and the rules followed for filling up the post of store supervisor in the organization. First up, the learned CGC, Mr. Parasar submits that he be given some more time to obtain instruction in the matter and appraise the score. In view of the above and on the joint request made by learned counsel for both the sides, let this matter be listed again on 28th of March.
27th of March.
27th of March. 27th of March is not Tuesday.
27th of March is Monday.
28th of March, my lord.
28th of March 2023 as a fixed item for hearing. On the next date fixed, the learned CGC to place entire instruction appraising this court as to what action, if any, has been taken for filling up the vacant post of store supervisor, and also as to whether the petitioner's case can be considered for the purpose as a reserve category candidate.
Interim order to continue, my lord.
Interim order passed earlier to continue.
Deeply obliged, my lord. Well, this is my This is also I'm appearing, my lord. The petitioners, briefly speaking, my lord, the petitioners are the turners. They're specialized in machine work, my lord.
You have not challenged the 2012 rules.
My lord, it's because I'm not on the issue, my lord. What is happening, my lord? 2012 rules that is now in 2022. My only limited humble submission, my lord. They are the turner specialist in machine work, my lord. They are covered by 1982 rules. When they join, my lord, it's covered by YB Rangia's judgment, my lord. They are born on that rule. Subsequently, my lord, they are to be promoted to the charge mechanic, right? And there is an amendment in a rule in 1996, my lord. In the same rule also, they are to be promoted to 1996 charge mechanic, my lord. Now, in 2012, my lord, what they did, they say, no, you are not eligible for any promotion. So they have declared me as a isolated cadre. Though I am contributing a lot for the organization in Eastern West.
Mr. Das, you seem to be emotionally very, very correct. But unless you challenge the provisions of the
My lord,
rule,
I draw my lord's attention to only 4 letters. Just for a moment, my lord. What they have proposed to me, what they have given hope to me, I draw my lord's attention to page 90.
page 90.
90 and Annexure 8, my lord.
Yes.
Para 3, my lord. This is the letter issued by the appointing authority, Director General Border Roads. Right, my lord? In 20th September 2010, is however the matter pertaining to the promotional expense of welder, blacksmith, TCS, turner. Here I am turner, my lord. Machine assessor who do not have promotional challenge at present has also been considered. This stage is recommended to be given promotion as per the scheme extended to empty drivers, that is ordinary grade, on the analogy of the scheme applicable to drivers. It has been recommended for such stage to obtain government sanction to implement the scheme, which may be taken up separately till such time the MSCP scheme will be operational. For this stage. Data review has been submitted to CDABR, that is Border Road, Joint Secretary Border Roads, by Director and note dated so and so. This letter is issued by my appointing authority, Headquarter Director General Border Roads. Then, my lord, I draw my lord's attention to page 108, Annexure 10. They have asked comments from the Chief Engineer, my lord. In this letter 16 October 15, para 4 of page 109, I draw my lord's attention. I read, my lord, therefore, keeping in view of promotional aspect, as well as introducing higher gateway of welder turner, the application addressed to headquarters DGBR grievance cell in respect of the above-mentioned gave persons are recommended for including in ensuing series conference for deliberation. My lord, now I draw my lord's attention to letter 114.
Mr. Gupta,
My lord.
114.
what do you have to say? You are lucky that he is not challenged the rules. Otherwise,
My
I would have granted relief to them by reading down the rules.
My lord, and
You are lucky. He is refusing to challenge the rules.
my
That
lord.
is the reason why the court's hands are tied.
Yes, my lord, because yes,
Otherwise, we would have read down the rules and you have to provide promotional avenue to everyone.
Yes. Further, my lord, no mandamus can be issued.
That's
for
right, no
framing the-
matter, but he is not understanding this,
My lord.
what to do. That's why I said you are lucky.
My
Otherwise, I would have allowed this petition today itself.
my lord.
My lord, then only, I guess a limited prayer before my lord. Then my lord, 114, it is issued on 10 July 19. On similar matter, they have asked that yes, a consolidated case will be taken up with DOPT for amendment of RNP rules of the statesman for getting promotion in higher scale. The appointing authority says that they are going to take up the matter of the DOPT for amendment. So I have not challenged, and my lord, one very honest submission is that 2012 rule, I am on 2019, I have filed it. That rule-making authority has got the power. It's a
Mr. Das,
policy. And my lord, only have my submission before my lord is that let them consider based on the so many recommendation even in 19, forming a committee or otherwise to tell whether they deserve promotion or not. That's all. I only say that.
Mr. Das, it's very difficult to say anything more, but we can only say that had you challenged the 2012 rules, this court would have read down the rules and made them, compel them to consider your client's case for promotion. If you don't do it, a mandamus cannot issue. What they would do, what they would not do is another thing, because that is the law. We have to go by the law,
Yes,
not
my
by
lord.
what is
I humbly
understood
submit, my
by
lord.
any counselor. If you can show us any law which says that no, because your case is that the rules are blocking your client's promotion.
They have deleted in that from my lord, one humble submission. Since so many recommendations,
I will tell you the reason. You are it looks like you are a retired BRO employee.
Yes, my lord. Yes.
That is understandable. That is what happens. We appreciate your enthusiasm, but the law has to be understood.
Yes, my lord.
These are service matters. The Reed Court and the High Court will go by the law.
Yes, my lord.
We are not sultans to pass.
Yes, my
you see.
lord. Yes.
The law is this, that the power to issue writ is a discretionary jurisdiction.
Yes, my lord.
The writ courts would not issue a direction compelling the authorities to act which is contrary to the rules.
Yes,
That
my
is why no relief can be granted to your client, because there is no challenge to the rules. But the moment the rules are under challenge, we can ask their opinion and read it down, strike it down, modify it, issue directions, because in that case, they will have to give an answer. Why these rules, how the rules stand the scrutiny of Article 16 of the Constitution of India. These are some of the materials you read and you will understand what is the
Yes, my
problem
lord. I
here.
agree, my lord.
Merely by asking will not do, because our orders lay down precedents. It is not that one order passed in
Yes,
one
sir.
case will be like a civil court order. It's not that.
I agree.
So
I humbly agree with
that is the difficulty.
respectful submission.
It is
my lord.
not that the court is against you or your client.
My respectful submission, my lord, with reference to so many recommendations, my lord can refer the matter for the reconsideration.
We cannot, because they cannot reconsider your case unless the rules are amended.
And if I am agreed, I'll challenge it further.
They cannot. We cannot ask them to do something which is against the rules. That is the problem. That's what I can talk to you for 2 hours, after which
No,
you
no,
will
my
also
lord, I
agree.
agree. Then should I withdraw the petition at this?
I don't know. I can't say.
Then I withdraw my
These
petition.
are matters, we have dealt with this kind of matters last 25 years.
Yes, my lord.
It's a matter of 5 minutes. But you are hit by a very, very serious technical lacuna.
Yes, I agree.
Unless you remove the lacuna.
Because
nothing will be.
the reason behind it that, yes, they have a policy.
What is that
meeting.
Bihar case?
My lord, one judgment I had, my lord.
Where is that Bihar judgment?
My lord, that one, 2021 5 STC 638. My lord, paragraph 45. Paragraph 45, my lord. And I have one more recent judgment also of April 2022. Paragraph 45, my lord, says judicial may read. Paragraph 45, my lord.
What is the principle say?
My lord, it says, my lord, judicial review of a policy decision and to issue mandamus to frame policy in a particular manner are absolutely different. It is within the realm of the executive to take a policy decision based on the prevailing circumstances for better
So
administration.
that's not relevant here, but the law is that Every employee is entitled to at least one promotion in his
But they are
entire
getting
career.
MACP, ACP benefits.
That is different. Promotion is different, MSc is different.
In lieu of the lack of promotion avenues, my lord, they are getting the MACP, ACP benefits.
Advancement of career, that is through
Monetary
promotion.
upgradation, financial upgradation is being given to them.
Mr. Das, yes.
Yeah,
yes,
I agree with you. My lord, give me the liberty to withdraw the petition. I'll challenge the rule.
That can be.
All right. Mr. T. Das, learned counsel appearing with the petitioner submitting that. But are you doing it only because the court is you satisfy
No, no, no,
yourself?
I'm satisfied, my lord, because
This
I
is not
had-
our job.
No, it is, no, I am satisfied, my lord. I felt it, but I thought that is a policy decision, but since so many recommendations are there, I thought they will take some
So
deliberate action.
let them take it, but you want an order
Yes,
from
my
the
lord, I
court.
humbly submit,
That
my
is
lord.
another
I
thing.
withdraw the petition in
All right,
liberty
Mr. T.
to
Das,
file a
learned
fresh
counsel
petition.
for the petitioner who seeks leave of this court to withdraw this petition with liberty to challenge the 2000, challenge, what is the name of the rule?
2012 recruitment and promotion.
Challenge the
It's a 3rd October 2012, my lord, notification.
Ministry of Road Transport and Highways, comma,
Page 85.
Border Roads Development Board, comma, General Reserve Engineer Force, bracket, Border Roads Organization, bracket close, comma, Junior Engineer, then bracket, Electrical and Mechanical, bracket close, Group dash capital B, Posts, comma, Recruitment Rules 2012. Page, what is the page number?
Page 85, my lord.
Page 85, check it once there. Full stop. Mr. H. Gupta, learned CGC appearing for the respondents is present and does not have any objection if the prayer is allowed. In view of the above, this writ petition stands disposed of on withdrawal with liberty as prayed for. But there are judgments of Supreme Court, 1985, 89. Go through those judgments when you draft it.
Yes.
There the law is that at least one promotion should be provided to everyone. And there also, there was a statute which had not provided for promotion.
Yes.
See what relief was granted.
Yes.
Accordingly, draft your petition.
Yes.
If you come up with a petition which is not in accordance with law or which is prepared without understanding the law, then there will be difficulty at some stage.
Deeply obliged.
Because the judges will go by law,
Yes,
not by what council understands or doesn't understand. We have no option. We have to
Yes.
go by law. Yes.
Obliged.
What is the next matter?
Item 21.
I'll pray for some accommodation on 21 today. My senior has some difficulties for your lordship. The matter has recently come to our chamber, your lordship. My senior is engaged on this. Any date that your lordship fixes for the matter.
You are for whom?
I'm for the petitioner, your lordship. Our names have been shown on the other column, your lordship. It's an error. In fact, Mr. S. Wathakur was dealing with the matter.
Lordship.
Mr. M. Sharma, counsel for the petitioner submits that he, along with his senior, has been recently engaged in
Yes.
this matter.
Yes.
And therefore, 4 weeks further time is required to prepare and argue the case. Mr. H. K. Sharma, learned government, additional senior government advocate Assam appearing for this. Additional senior government advocate Assam appearing for the state is present and does not have any objection if the prayer is allowed. In view of the above, hearing of this writ petition stands adjourned for 4 weeks. List accordingly.
In fact, your lordship.
lordship, in my name, the K is not there, only.
Acha, H. Sharma, sorry. See, so many names
Lordship,
circulate, so sometimes
lordship, yes.
K is missing when it should not be missing, sometimes it is present when it should not be present. Sorry for that.